recollection because the court doesn't want to give undue weight or influence or suggestion to any one piece of evidence over the other. That's why I'm not answering your specific questions. So I don't mean to be rude or disrespectful, but you have to rely on your recollection. So now, we had one question for you, or maybe two questions. Are these your questions alone, or have you discussed this with other jurors?
No, my questions alone. Like yesterday, we had it, and it was like, and I guess I missed some of that information when it was given because I wasn't writing everything down. I wanted to listen to everything that was going on. So I may have missed if those answers to some of that.
Okay, understood. And have you observed any of the jurors discussing the case? Because they're not supposed to discuss the case until it's given to them for deliberations.
No.
All right. Thank you, juror number 38. One moment. Let me see if the attorneys have any follow-up.
I don't. I think we're good.
Okay. All right. Thank you very much. Yeah, you can go back to the room, and we have one more thing to do, and then we'll get started with evidence today. Sheriff, the gentleman in the back row far right, you know who it is? Oh. Okay, yes. So bring him out. I don't know his number. Oh, good morning, sir. You're welcome to have a seat. Thank you very much. And if you can give me your juror number.
Juror 33.
Thank you, juror number 33. All right. And again, I do want to remind you, your face is not being filmed and your information will not be released to the press. Okay. Yesterday you had a question, and so we would like to hear your question, and then we'll decide how to respond, and then we may have questions for you. So yes, sir, juror number 33, what was your question?
In this case so far, there have been a number of objections and information we've been told to omit from our consideration. In the event that while we are taking our notes and trying to recall information, we are unclear about what information is to be omitted, are we allowed to ask for clarification from what point in a witness testimony or from what point in conversation we are to omit from?
Okay. And I'm now going to turn to the attorneys. My position is by law that we give the response of you have to rely on your recollection as best as you can. Just come up with a different response.
No, not on that issue, Judge.
Does the defense wish a different response? And I do understand we're going to ask some other questions about the we part. But Mr. Rogers, just can the court clarify the objections and what was stricken and not stricken?
I don't have a problem with the court clarifying.
Okay.
As it did before.
What, giving the same response or offering clarity? Giving the response that he has to reply, the jurors have to rely on their independent recollection.
That satisfies the defense.
Okay. Ms. Steve?
Yes, Your Honor, I think my clarification that not only do they have to rely on their own recollection, but again, to instruct them that anything that you have ruled that should be stricken or should not be taken into account should be just done just so, considered or handled just so. They cannot consider it.
Okay, thank you. Okay, so juror number 33, and that is the response that the court is required to give by law, is that the jurors have to rely on their independent recollection of what the evidence is, and they cannot consider something that's stricken. Now, I understand your point. Well, what if I don't remember what was struck or not, and I got confused in the sustained, overruled? You can consider this, you cannot. Again, you have to rely upon your recollection as best you can. The fundamental principles in the Supreme Court law regarding that are that I don't want to, they frown upon the court giving emphasis to certain evidence over another. So that's why we don't try to verify. You have to receive it and make your best judgment. Because if I point it out for you, that can give it undue weight. Now, you use the the word "we" several times. Why do you use the word "we," and are you discussing that? Have other jurors expressed the same confusion?
The other jurors have not expressed that confusion to me. I posed that question to the other jurors and none had an answer.
Okay. And other than that question being posed to other jurors, have they discussed the case? Are you observing anyone discuss the case?
No, ma'am.
Okay. And the reason why I ask is because you're not to discuss the case, which is deliberate, until it's formally given to you at the conclusion of evidence. So there have been no discussions about the case?
No, ma'am.
Okay. All right. I'm going to turn to the attorneys to see if they have additional questions for you.
Understood.
All right.
We don't have any other questions.
Okay. Mr. Jacobs?
I don't have any questions.
Okay. Thank you, juror number 38. You can retire to the room. We have one more thing to take up, and then we'll start the case.
Quick correction, Judge.
You have a question?
No, quick correction. Just now, we referred to him, the court referred to him as 38.
No, 33. Thank you. 33. Juror number 33. I'm sorry. Thank you. You retire to the room, please. Okay. Anything that someone would like to address before we bring the jury out?
Your Honor, can I just step out for a quick minute? I'll be up here.
Yes, sir. I'll give you that. Keep your seats. 33. Anything in addition to his, or any comment on his responses?
Yeah, sure. Regarding juror number 33, I think what's most telling is what the juror stated while he was not being asked direct questions about whether they discussed the issue or discussed the case. Several times he used the word "we," indicating that there had been deliberating before a discussion of the case between the jurors. He stated that he asked a question about the objections and what they're to consider and what they're not to consider. And nobody could give the answer to that question. That indicates that there was discussion about the issue that he raised with the court. Moreover, the issue or the questions raised by juror number, can't remember.
Was that the young lady?
Yeah.
38. She's 38.
38. Your Honor, frankly, I think those questions were improper and have, kind of aided the Commonwealth with knowing what is important to the jury in real time as the trial is going on, allowing them to potentially shape their ongoing examinations of their witnesses. And so, Your Honor, for that reason, we believe that we're making a motion for a mistrial.
Can I have just a moment?
Yes, sir.
Judge, with respect to the issue with number 33, sort of announcing this question to the panel, I share the defense's concerns about that. It sounds to me like the question almost suggested to them that they should be confused about it and started to start them reasoning over the evidence. So I share their concerns about 33. I don't share the concerns about 38 that were mentioned because I can't change what my evidence is based on what they asked. Like I couldn't suddenly admit a 911 call because no 911 call was provided in discovery. You wouldn't be allowed to do that, for example. However, and while I know number 38, I feel like number 38 has, begun to form conclusions in her mind about the case as well. And given that, I think I have to agree with the defense's motion.
I will recess to consider this. Again, we also have two alternates. So we could release jurors 33 and 38 and still have 12 jurors. But I do understand your concern that, again, let's parse this up. Jurors 38 were her questions alone and were not shared or disseminated with the other parties. So if there are concerns about juror 38's questions, juror 38 could be released as an alternate and we still have a constitutional jury panel. Juror 33 did ask his questions of the other jurors, and we're all grateful the other jurors didn't respond and followed the cautionary instructions that the court did give not to deliberate until this case is given to you for deliberation. And now, let me add to this. The sheriff has indicated juror 33, the gentleman does have a notepad back there that was not a notepad court issued, but we don't know what's in the notepad. Let's bring him back out again and see what's in the notepad. Well, hold on, Sheriff. Yes, Mr. T.
Just for the record, Your Honor, regarding juror number 33, his testimony, from what I recall, was not that they did not answer him. He's saying that they didn't have.
Oh, they said, yeah, you're right. They didn't know.
Right.
The answer.
So there's, to me, that indicates.
So let's follow up on that. Yeah. Okay, bring out juror number 33 again, please. Okay, and you can have a seat, juror number 33.
Thank you, ma'am.
Okay, two questions of clarification.
Absolutely.
I do understand you said you asked your questions of the other jurors, and if you could give me the detailed verbatim responses you received, whether it was they did not answer you or they said words, if you could give me the your recollection of those conversations, and with how many jurors?
My recollection of the conversation was when I posed the question, our officer here, and he said he could not answer it, would present it to you.
And you posed the question to who? Oh, okay, gotcha, the sheriff, okay?
Yes.
And he said he could not answer it.
Could not answer those questions for the judge. And he stepped out. I said, I'm just curious about making sure that our information is accurate. Trying to remember verbatim the responses. But generally it was just I apologize, I did not try to log that in my memory. I don't remember any particular responses as much as that might be good to clarify, would be good to know. And the conversation moved on, I believe, to traffic cameras. So, I believe that was the extent of the conversation. I'm sorry, I can't be more
So your memory is fine, and so did were there responses, or did they greet you with silence? Did you receive responses to the question?
The only responses I can recall to any extent was a general assent that clarification would be good to have.
Okay, and how was that general consent, that clarification would be good to have conveyed to you? Was it a physical gesture? Was it a verbal?
Verbal responses to the extent of something to the effect of, oh yeah, that would be pretty good.
Okay. And do you know how many would have shared that, if you can approximate?
Maybe 3 or 4 people at most.
Okay. And those are my questions for you, but again, as procedure, I'm going to turn to the attorneys and see if they have additional questions.
So you just sort of in passing mentioned that the conversation moved on to traffic cameras.
Yes.
Is that right? Was it like, could you describe the nature of what that conversation was?
Trying to remember, because it's going between considering my question, sipping my coffee, and generally paying attention to traffic, so I apologize if this is not totally specific. We're trying very hard to not discuss the case in any capacity, and so we're finding other topics of conversation. People were discussing times that have been clocked by traffic cameras.
Okay, so
that type of thing.
Sure. So it wasn't in relation to is there traffic camera evidence in going to be shown in this case? Okay.
No.
Oh, thank you. I don't have anything further.
Okay. Mr. Rogers and Mr. Teague?
Yeah, we're good.
Okay, no additional question. Okay, and then juror number 33. It was mentioned to me that you had an extra notebook. Are you recording any notes from the trial in that extra notebook?
The extra notebook was the initial notebook I brought in. I was unsure if notebooks would be provided to us. I left it here with the other one. I believe it just simply says jury notes and the date. And when I heard that we were not allowed to make other notes, the notebook was placed down on my feet and has not moved from that position.
Okay, wonderful. Thank you. And
You're
so
welcome.
again, let me, because I changed the topic, I'm going to turn to the attorneys and make sure they don't have any additional questions.
None from the Commonwealth?
Okay, thank you, juror number 33. And again, you are not in trouble, but we just have to make sure everything is perfect. And it's very important that you can retire back to the jury room. Thank you very much.
Thank you, ma'am. Thank you again, Tim.
Okay, anything additional before I take a recess to research and consider the issue? The mistrial motion made based upon juror number 33 having conversations with the other jurors.
My position remains the same. Nothing further.
Our position remains the same, and just want to note that the juror seems to not remember, according to him, not remember the exact conversations that went on regarding the issue.
So again, I'm going to retire for deliberations. Just for human planning purposes, it'll probably be at least 15 minutes. So if people need to use the restroom or go to the car or something, please feel free to do so. I'll be honest, I'm inclined to deny the motion, even though both parties have made it. As the question for clarification, did you understand that? And the responses, I think, will be harmless, but let me research it and consider it in detail. And I'll be back in, let me see, it's 9:54. Let's see, try to check in at 10:15. And then, Madam Harry will make sure jurors have, extra snacks and whatever they need. Because they've been in that room a good hour and 15 minutes by that point. Okay, I will be in recess. Thank you.
All right.
All right. We are ready to resume the case of Commonwealth versus Parker. All parties are present in the courtroom, minus the jury. And there was a mistrial motion made. And of course, we had an opportunity to consider it and research it. Anything else parties want to say before the court announces a ruling?
Nothing from the Commonwealth.
Your Honor, just for purposes of the record, I just want to clarify the motion as it relates to juror number 38. She submitted a series of 3 questions, which again, we're arguing that helped, I believe, would aid the Commonwealth in planning out the rest of their case directly in response to her questions.
Thank you. And in response to the mistrial motion made regarding juror number 38's question, the court will deny that on the legal principle that the jurors in this matter are actually the triers of fact. And under law, they can ask questions of the witnesses. Now, of course, our courts aren't set up to do that. We don't encourage it. We don't normally do that. But it is not prohibited. All the evidence has not been presented in this case, and both sides can adjust accordingly based on those questions. But again, jurors are the trier of fact in this case, and they do have the ability to ask questions and can actually question witnesses. So that's the legal principle there. Regarding the motion to mistrial based upon juror number 33, asking questions of other jurors, which means discussions prior to the case being submitted to them for deliberation. The defense has moved for a mistrial. The Commonwealth has joined. The court is going to deny the motion for a mistrial, and the case will proceed. The court's rationale is as follows. The determination of whether a mistrial is warranted depends on whether the juror misconduct probably resulted in prejudice to the moving party. The burden of establishing this probability of prejudice lies with the party seeking the mistrial. The standard is abuse of discretion, and to succeed on a motion for mistrial, the moving party must demonstrate a manifest probability that the misconduct was prejudicial. The allegations of juror misconduct arise, or if the allegations of juror misconduct arise, the trial court may be required to investigate the matter to determine whether the prejudice occurred. In this case, the defense, which is the moving party, has not established a manifest probability of prejudice. The court did investigate the juror misconduct. Again, Virginia courts have delineated between misconduct inside the jury room and outside of the jury room. In this case, this would have been not outside, such as unauthorized communications with third parties or introduction of extraneous evidence, but it was misconduct confined to inside the jury room, specifically premature discussions among jurors. And case law has indicated that that is less likely to result in a mistrial unless it demonstrably affects the fairness of the trial. And in this instance, juror number 33 had questions about procedure to other jurors, not questions of fact. And I also want to make that distinction here. In addition, Virginia statute does provide a mechanism for addressing juror misconduct. And that is 19.2-262.01. So in summary, the misconduct here was not prejudicial, or is not prejudicial as found by the court, a legal decision, and a curative instruction can be given, and I will again bring them out and tell them that they are not to discuss the case, ask questions of each other about the case until it is submitted to them for deliberation. The case law that the court is relying on is Robertson versus Metropolitan Washington Airport Authority, Reiner versus Commonwealth, Caterpillar Tractor Company versus Holvey, and Bidet versus Commonwealth, in addition to the statute cited. All right, so with that being said, motion is denied and we're ready to move forward. Can we bring the jurors out?
Judge, I understand that the defense has an objection to the authentication of the video that the court has already considered, and that objection is going to require me to lay a foundation by showing her the video and asking her to authenticate it.
Okay, so we want to do that outside of the presence of the jury.
I think so, and to hear her both sides.
Mr. Rogers.
That is correct, Your Honor. Instead of bringing them out and then having to exclude them again so we could lay the foundation and authenticate the video, I think it's for judicial economy, we should just go ahead and bring her out, follow her, authenticate the video, and then if the court believes that the authentication is proper, go ahead and present the evidence to the jury. Your Honor, I do have another concern, and that is at the beginning of the trial, the court ordered that all witnesses be sequestered back in the witness rooms. I think there's at least 3 rooms, and I think there's multiple witnesses in each room concerning that they may be discussing the case, may have heard about the evidence that has been presented in the case, and may be discussing that. And so I'm concerned that the court's ruling on sequestering the witnesses may have been violated, and is being violated.
Okay, and again, I believe there are over 20 witnesses in this case, and we don't have the physical space to give them their own separate rooms. But of course, they are sequestered, and it's on the attorneys to identify them and to instruct their subpoena witnesses as to the rules. Do you have a basis for believing that they may have discussed the case?
No, I'm just believing that's a probability, of course.
Probability just because they're sitting in the same room.
And they're talking, but of course I'm not in there. I don't know what they're speaking about.
All right. Without more specific information, that the court is going to deny your motion, but feel free to voir dire them regarding that when they take the stand. Okay. And Commonwealth's witness that we're going to pre-clear the testimony for evidence.
Yes, Your Honor. Nina Farish, Dr. Farish.
Okay. Bring out Nina Farish, please.
Raise your hand. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Okay.
Watch your step. There's a stair, and the chair and microphone are adjustable. And Ms. Farish, we're going to take up some of your testimony outside of the question for the jury. We've got any objections and evidentiary issues, and depending upon the ruling, we might bring the jurors out, and then redo it. So I just want to explain to you procedurally what's happening right now. Okay. If the attorneys have any questions, we'll start with the combo. Yes, Mr. Rogers?
Before the video was played, I would like to coordinate her during the video prior to her actually viewing it.
Okay, and I don't know what order Mr. Jenkins is going in, so do you want to start with the questions, Mr. Rogers?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
Okay. Yes, please proceed.
Good morning. Could you please tell us your name and how you're employed?
Nina Farish, Human Resources Director with Newport News Public Schools.
Were you employed in that same capacity in January of 2023?
Yes.
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Rich Neck Elementary School that occurred on January 6, 2023?
Yes.
As part of your investigation, did you have occasion to interview numerous people?
Yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom,
Okay.
recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes.
And what was, prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
Assistant principal.
Okay. And do you see Dr. Parker in the room right now?
Yes.
Could you please just point her out for the judge?
Okay.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes.
All right. And was that was that interview conducted in person on Zoom or some other way?
Via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes.
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think, does.
Good morning, ma'am. How are you? Great. So, regarding any video that was produced, did you keep, or were you the sole custodian of that Zoom video?
Yes.
Okay, and where was that video maintained?
On my computer.
Okay. Did anybody else have access to your computer, or was it just you?
Just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys.
When you say the attorneys, what attorneys?
The ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins at Commonwealth?
No, I'm trying to remember the name of the law firm because,
So
as I recall,
so the civil attorneys?
Mr. Jenkins was not the original attorneys.
The civil attorneys?
Correct.
Okay. So have you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes.
When did you review that video?
I reviewed the copy that I still have, and I reviewed it to refresh my memory.
Okay. I want to make sure that you understand my question.
Okay.
The copy of the video that the Commonwealth has, have you reviewed that?
I'm not sure how to answer that question because if I didn't give it to the Commonwealth, I don't know which video then you're referencing.
That's right. So you did not personally give the Commonwealth attorney a copy of the video,
No.
and you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into the possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Okay, and this recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it stored on Zoom's the Zoom app, or how is it actually how is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
I would call it the original because I've never, except when subpoenaed, made a copy.
Okay, and again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you. I'll tell you what, I'm going to let Mr. Teague step in.
Good morning, Ms. Farish. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
Well, I pressed record, but it was the Zoom platform that's recording.
Okay, so you did not actually record it with your own device or anything like that?
No.
And so the actual video was something that you downloaded from Zoom? Or was provided to you later via Zoom, correct?
Repeat that question.
You said, I believe the testimony is that Zoom recorded it. You pressed record on the Zoom platform.
Correct.
And Zoom recorded it.
Yes.
And then you were able to, I'm assuming, download it in some way? Or how did you get it onto your computer?
I have the Zoom app, so then I just reopened the recording, and it can play for me.
Okay. Thank you.
Okay, and one moment, Dr. Parrish, any further questions before we,
Just arguments at this particular time.
okay, and your arguments are towards the video?
Your Honor, she testified that she cannot verify the accuracy of the video that the Commonwealth has. She hasn't viewed it. She's testified that she cannot verify that the whatever video the Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video. It could have been run through artificial intelligence and altered. She testified that she can't. She's not in a position to be able to verify that.
Do I have permission to play the video?
Yes. And Mr. Rogers, did you want to say something?
Your Honor, what I don't want to happen is that she's already testified that she cannot verify a video that's in possession of the Commonwealth is accurate. So what I don't want to happen is for her to see the video and just sign off on it without actually having it examined ahead of time to determine its accuracy.
Judge, if I may.
You may.
The two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that. It's just longer and contains what I believe to be pretty irrelevant, but I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
All right, and the 3 clips, are you able to give me a duration of each clip?
Because they are in one file,
And if you can't, that's fine. I just didn't know if you can.
the total duration of the 3 is, let me make sure before I say.
Your Honor,
16 minutes and 36 seconds is the total duration.
Okay, thank you, Mr. Jenkins. Yes, Mr. Rogers?
Your Honor, Commonwealth has already admitted that the video has been altered. So with that admission, she can't authenticate it. There's been, Commonwealth would say minor alterations, but Your Honor, I'm not comfortable with just presenting clips. She needs to authenticate the whole video, and if part of it comes in, I think all of it is coming in.
Okay. Do you have any authority for that position, Mr. Rogers? Because I'm unaware of the authority that if she is able to say that this is an accurate, fair and accurate representation of the interview she conducted, what authority indicates that it can't be redacted to the relevant parts and that you cannot mute sensitive information such as the names of minors involved? What authority do you have for that that makes it inadmissible?
Your Honor, I don't have any authority regarding the muting or the name of a minor I'll just cite Baez versus Commonwealth. And I've got a copy of it before.
And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. It doesn't address that.
Okay,
Just-
but the other thing you're saying, if they get parts, I want the whole one. How do you wish to do that?
Your Honor, I just, I'm going to object to just a part of it because of the importance of context. If some of it comes in, I just believe that the jury is entitled to it.
And Commonwealth, they're not objecting to that. So what I'm asking you is, how do you want that? And well, let me back up, Mr. Jenkins. How long is the entire interview?
I will have to look at that.
That's when I asked Mr. Rogers, are you asking him to play the entire interview?
Yes, ma'am, essentially.
Okay, that's what I want to know. How long is the interview?
The whole video is 28 minutes and 58 seconds, I show. Let's see if that's right.
Okay, that's fine. Okay, all right. So we'll play the whole video for the jury should it meet the other identification things. Anything else, Mr. Rogers?
That's it.
Okay. So Mr. Jenkins, what are you prepared to play now for the witness?
Well, I can play the whole video if that's what it's going to take to authenticate it. If defense counsel would agree to let me show her a freeze frame and verify, we can do it that way. But
Mr. Rogers?
So I'm going to ask that she be shown the entire video, but then when it comes down to the presentation of the evidence, then I would suggest that the Commonwealth can show clips at that point. But I want the jury to have the whole video. I want the whole video reading the evidence.
I think I understand that the defense is wanting to admit the entire video into evidence on a disc so that the jury could see the whole unedited, unredacted video and only play for the jury the clips, the 3 clips with the redactions in place. And if that is what the defense is suggesting, I do agree to do that. I think that's fine.
If the court feels that it has been properly vindicated.
Okay, all right. So we agree to proceed in that manner. Except she doesn't need to watch the entire thing. Ms. Farrah, she's going to show you portions of the video and ask you questions about it. But in terms of the entire video, if at any point you say that that's not accurate, please let us know. But
Your Honor.
yes, Mr. Tibbs.
Just before we start, I would note that Mr. Commonwealth has indicated that all of the 3 clips have been melded into one file, so they've been joined together, which I think obviously would mean that it jumps from clip to clip without the context in between. So I do believe that there may be some issues with playing just those 3 clips, especially if they're in one melded video that's combined into one file. I don't think that would be. I don't think that would be fair to Dr. Parker because it would leave out. I'm assuming that he's jumping. Having seen this video, the splice one, it jumps. He's saying that he's joined 3 clips together into one file that plays continuously.
Okay, well, let me hear from Mr. Jenkins.
Judge, the 3 clips that I'm playing are melded together, so to speak, as defense counsel says. But I am happy to tell the jury, and I'm sure Your Honor may as well, that I am showing clips and that they will have in evidence the full unedited, unredacted video. And the jury can know that up front, and I see no problem with that.
Okay, and to the 3 clips because they're spliced. In between the splicing, is it obvious on the video that this is a splice and we're going to jump forward in time and hear another portion and then we're going to jump forward in time?
It makes a small jitter or jump, it is all, but it doesn't, fade to black and come back up.
Okay, so there's some kind of visual signal that something is happening.
Admittedly, you have to be kind of watching closely because it just jitters. The people move oddly, and that's when the new clip starts.
Understood. Okay, so what is defense motion? Because Mr. Rogers said it's okay to play it, but as long as they get the entire video for deliberations, Mr. Teague is saying play the entire video. We're talking about 12 extra minutes.
Yes, Your Honor, I think that that's an alteration that goes beyond using people's names and clicking, making slices that are obvious to the jury. I just don't think that should be played to the jury.
Given that, Judge, here, I am offering that into evidence. That is what I'm offering, the clips. And the counsel is free to offer whatever they'd like. They have a copy of the video.
We don't agree to admitting a spliced, altered video into evidence. We just don't.
Okay, give me the authority that indicates that that's not admissible. I'm not aware of it. Okay, and Mr. Rogers, what case law have you handed up?
Your Honor, this is Commonwealth, Supreme Court of Virginia, December 19th of 2024. And so I will begin, but the rules begins at, you'll see designated paragraph 1819. That's probably like 6 pages back.
Sir?
It says, beginning of that paragraph, it says, photograph or video which is verified by the testimony of the witness as fairly representing what the witness has observed is admissible in evidence, and it need not be proved by the individual who made it. And then I'm just going to go on down. It says, as a silent witness or a witness that speaks for itself, video or photograph evidence is admissible when given an adequate foundation ensuring the accuracy of the process producing it. Obviously, this splice video is not something that she's going to be able to verify the accuracy. And so, going down to paragraph 2223, focusing the authentication quality on one discrete moment with 2 more to bear on the genuineness of the video as a whole. And then going down to paragraph 24, it says, for witness to affirm that a video is accurately so in terms of video, witness is not necessarily a witness is willing to testify at every moment, but rather it's sufficient for a witness to affirm the video accurately represents what transpired based on the witness's observation. So, Commonwealth has submitted this video in its form as it's been offered. Obviously, the Commonwealth is going to be presenting a video that points more to Dr. Parker's guilt than innocence. So, in this form, it's highly prejudicial to Dr. Parker, and we don't believe that just social justice should be presented as the Commonwealth has a certain prepared. Obviously, Ms. Ferris has not seen the clips in the form, and so she can't verify the process of how even these clips were produced.
Judge, would you like me to respond?
No, sir. So the court is going to allow the Commonwealth to play the 16-minute clips of what the relevant portions are to the Commonwealth in their perspective. Again, the evidentiary rules are about reliability. Is the thing what it purports to be as proclaimed by the proponent? Are the legal principles involved? And is it a fair and accurate representation? Once those are satisfied, it comes in. I note the defense's exception. Mr. Rogers also brought in the word prejudicial. I don't think he's laid an adequate basis for why this is prejudicial. So you may proceed with your attempts to authenticate this, and then we can get moving with the jury trial.
Okay, Your Honor, given the court's ruling, the video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the 3 different clips.
Yes, sir.
Your Honor, before we go, so there was discussion about if the video was admitted, presenting the complete unredacted copy to the jury. Was that still?
Is that still a defense request? And Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. All right. Yes, sir. You may proceed.
Thank you, Judge.
Okay. So Dr. Parker, thank you so much for joining me today. I'm here to first ask if you are giving permission for me to record this session to discuss the incident that occurred in Richmond on Friday.
Yes.
Okay. So as part.
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Okay. Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview.
Mr. Rogers?
She's only seen my client's face. She's certified that I was just going to ask it for purposes of identification. There's no way she can verify that what's on this 16-minute clip is accurate. She has to see it.
Ms. Jenkins, if you just jump to 2 other sections, if you're able to, and play about 10 seconds and ask the same questions.
Okay, I can. Oh, sorry.
Sorry. I'm seeing at the bottom of this screen a date and time stamp, and those are military hours. So those will move as you move your cursor?
Yes,
Okay.
Your Honor. So I can make a record of those.
Okay, and I didn't know if that's on video or if you have another cursor mark on your laptop that's showing the different timestamps.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video, but what I believe is on here is in the date and time it was recorded.
Okay, understood. Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
And he left. But those are the only 2.
Okay. So help me understand.
And Dr. Ferris, does this still seem to be your interview with Dr. Parker?
Yes.
Okay. I'll jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay. All right. So just to be clear.
And Dr. Farish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
All right. Judge, with that, I think we've laid a sufficient foundation for authentication purposes for this video.
Anything additional from the defense?
No, just to try to stress the whole point of authentication is to verify accuracy. Your Honor, it's going to be the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this record to the Commonwealth. She gave it to other attorneys. We don't know what kind of manipulation occurred in the possession of those other attorneys or any IT professionals, any other person between the chain from Dr. Ferris, the other attorneys, and Master Commonwealth. just showing her those very few seconds that she's not verifying the accuracy. She's verifying that essentially that's her talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that video.
Yes, sir. Okay, so again, the defense will continue to note their objection for the record. The court, again, is going to allow this video to be played to the jury for the rulings it's previously made. But again, the defense exception is noted.
Judge, may I please request to make a quick record related
You
to
can,
that?
I'll let you make a record.
Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter.
Yes, ma'am.
All right, thank you. Yes, Mr. Jenkins.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. So it is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
Sheriff, you kindly bring the jury out, and we do ask all parties to stand while the jury comes out. If you're able, if able.
Your Honor, I'm going to step out and let that.
Okay, well, step out, Mr. Rush. Yes, sir. We'll wait till you come back.
Thank you.
I'm sorry, everybody. Get your knees in your back stretch. Yeah, it's a good stretch break. Let's stretch. There we go. Madam Clerk, Madam Court Reporter, you all good? Yes, ma'am. Okay. Okay, all attorneys are back in place, and we will bring the jury out. Thank you, Sheriff. And again, okay, let's practice again. Let's all stand. Let me stretch.
Jurors in the box, please.
Thank you so much. Everyone can take their seats, please. Do you mind? After the head count. Happy Wednesday to everyone. Thank you for the time. This morning. I know you've been there for about 2 hours. We were working on some motions to hopefully keep a swift pace through the day. As usual, we'll try to break around 1 and try to conclude around 5 for evidence for the day. And if you need any breaks, let me know. Now, I haven't asked the parties, the juror box as a whole, but we have that cautionary instruction not to research this case outside of what's presented to you in the courtroom, not to discuss it with others, and if somebody approaches you, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction. Again, amongst yourselves, please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. So you can talk about the weather, talk about family, but just don't talk about the case or questions amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in, and the Commonwealth will start their direct examination. Mr. Jenkins.
Thank you, Your Honor. Good morning again.
Good morning.
Would you please tell us your name and how you're employed?
Nina Farish, a Human Resources Director for Newport News Public Schools.
And Dr. Parrish, how long have you been in that role?
For 4, going on 5 years.
And so were you in that role on January 6, 2023, and in the month of January 2023?
Yes.
Do you know someone named Dr. Ebony Parker?
Yes.
And was she employed by the school system?
Yes.
How so?
As an assistant principal.
Okay, and is she in the courtroom right now?
Yes.
Could you please point out?
Yes.
And Judge, I'd ask the record reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Rich Neck Elementary on January 6, 2023?
Yes.
And after that incident, were you called upon to investigate it?
Yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Rich Neck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes.
Did you conduct an interview with Dr. Ebony Parker?
Yes.
And technically, how was the interview done?
Via Zoom recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes.
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken. May I publish to the jury?
You may, and for the jury, the defense has objected, and the court has allowed that the video will be played. I don't think it requires dimming, but do either of the attorneys want the courtroom to be dimmed?
Not necessarily.
Okay, you may proceed.
Okay. So Dr. Parker, thank you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Rich Neck on Friday.
Yes.
Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer the questions honestly. Also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So, Dr. Parker, let's start with Friday. were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that students reported that the student had a weapon in his backpack.
Do you remember? Okay.
So, Ms. Kodak, we're allowed to use names, right?
Yes, ma'am, please.
Okay, so Ms. Kodak was the one who informed me of this. And she said that she had already asked the student, you know, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside to recess, so I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter road assessment, putting off tickets and stuff, so I didn't go into the classroom with her. When she came back, she says, there's nothing, you know, I didn't see anything in his backpack. And I said, okay. And she said, but, you know, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So, I don't know if she went outside or not, but there was a comment that said that we watched him closely. Assuming she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of that conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you, the students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between it, but I know from the time that she said it to the time that we went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. I didn't. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at 1. That was at, the meeting was at 1, and I didn't make it into that meeting. But because I was in the midst of testing, I don't leave my office when we're in testing to maintain, you know, the testing tickets and the security of that. And so I had not spoken with Ms. Foster.
Okay. So can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So, after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask, you know, should we check his backpack? Do we check his backpack? Mr. Rawls, after that situation was settled, came back into my office and he said, hey, did you hear what they said about? I said, yeah, I heard. I said, but we checked his backpack. And again, I'm still using we, but it was Miss Kovac. I said, his backpack was checked, we didn't see anything. And he says, oh, okay, did you check the person? And I said, ooh, no, we didn't. And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and then she can, you know, we'll let her go through the rest of his things and check it. He nodded his head and he left. but those are the only two.
Okay, so help me understand, what is your understanding of what should have taken place from the first notification that you received about the student from Ms. Kovac possibly having a weapon?
What we did in previous times before, we had two other students who also reported to have a weapon, and we, asked the student, if do you have something that say, no, we do have someone else come in with us to look in their backpack, but we never searched a student. So because we didn't, Ms. Carter didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day, and we have a conversation every day. So I was waiting for mom to come in.
So in the past protocols of what you've done, correct me if I'm wrong, you've brought the student into your office, and you, along with who else?
So the first time it was Mr. Rawls, and then the second time it was an incident of a parent had already called the police because the report was given to her from her son, so she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Mrs. Warner on that Friday come to you and express concern about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Warner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, oh, okay, and then she left. So I told Ms. Kovac, because they were going to look back at the kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Ms. Warner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't. She didn't say that to me.
Okay, all right, take your time. Had Ms. Warner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
No, so has been on my schedule since the beginning of the year. His acting out was he's extremely defiant, and he does the exact opposite of what he's asked to do. And it was making it difficult for her to do instruction in the classroom. So we sat down and we made a modified schedule. We had things in place. So somebody was getting the bus. He was going to Miss McBurnett's room to do a social story. He was then transitioned to Miss Kovac for a 15-20 minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office, and he said no. Ms. Warner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated the meeting that afternoon with Ms. we told, hey, no the damage that it is to the teacher's phone, we'll let you know. She understood that she was prepared to pay for it and everything. So, in hindsight, that evening, I spoke with Miss Foster, and she said, I really think I'm going to call Mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but, I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Warner ever report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do. Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Miss West. And what Miss West reported to Miss Newton was that he was like pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that was what was reported Wednesday, that's where I think that came from.
Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. When prior to Friday, had anyone, Ms. Warner or anyone reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So, staff stating that administration knew, what is your response to that?
Could we pause the video?
Yes, you can pause it one moment. Yes, sir.
Can I have just a moment to talk with the council, and then I think I have an objection.
A brief moment.
There's a lot of, I would say, hearsay statements that are being propounded by Ms. Ferris, things that other people may have said. And so I understand the video is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Ferris, I would submit to the court that I believe those are hearsay. Any statements that she is alleging was made or declared by another party, I would submit is hearsay, and I would ask the court to instruct the jury not to consider statements of Ms. Ferris or what somebody else may have said, but only to consider my client's responses to those questions.
Judge, I would ask that we continue playing the video for now and make a decision about whether there needs to be some sort of curative instruction after that.
So I will, again, continue to play the video, but I will grant the defense's motion that will give a curative instruction. instruction. So we'll prepare that when it's time for instructions. Whose testimony they can consider from this video and the hearsay. All right, you may proceed, Mr. James.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
Yes, sir.
Administration knew. What is your response to that?
I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Warner, was asking for. Like, just, I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Warner was reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear on something. Ms. Kodak, check the bag. What is Ms. Kodak's title?
She's our reading specialist.
So help me understand why Ms. Kodak why would you direct Ms. Kodak to check the bag?
So, in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kodak, when they go out to recess, check his bag.
Okay. Did you talk to your resource officer that day?
She was not there.
Okay.
Oh, the resource officer, the actual, I didn't call, no. I didn't call. And our security officer, Ms. Lee, she leaves every day at 2 o'clock.
She leaves at 2, so Ms. Lee.
I'm sorry, not 2 o'clock, 12 o'clock. And she comes back after McIntosh's dismissal, for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay. Okay. All right.
Was what you just watched a fair and accurate depiction of some clips of a longer interview that you did with Dr. Parker?
Yes.
Judge, at this time I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker that contains the clips that have just been shown to the jury. I would move to enter that as Commonwealth's 2.
I so introduced over defense's previous objections, which were made contemporaneously, to be marked as Commonwealth 2.
And Judge, at some point I will need to take a moment to get the full and complete video saved to a drive, and at that time I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor. Dr. Finish, do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes.
And do you do that for the school district?
Yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes.
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year.
Yes,
Do you have that document with you today on the stand?
I did.
Would you mind pulling it out? And did you bring that with you today?
Yes.
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Okay.
Hold on a moment. Yes, what's the objection?
Lack of foundation, Your Honor. Ms. Ferris is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not made that the proper foundation has not been made.
How long?
The court has already ruled on that. It is
Well, we
a...
ruled on hearsay, but we didn't rule on foundation.
Okay, well, she has testified that on hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is in fact an authentic record of the Newport News Public Schools. She brought it with her here today herself, and that it was in effect on the time in question. So that's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Yes, Your Honor. So, thank you, Dr. Ferris. This is page 28, a paragraph that begins, principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Richneck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay. Please give me just a moment. I'd like to direct your attention to page 18.
Your Honor, I'm going to request some idea on her foundation of knowledge regarding this particular document.
Okay.
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room because admissibility is not a factor for them.
Mr. David,
Yes, sir.
and what's the basis for this again?
I don't think the proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not going to allow additional voir dire at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Ferris, let's back up. Is the multi-hazard crisis plan for 2022-2023 required by law to be created by the schools?
That is my understanding.
Okay, and are the plans records of the schools?
Yes,
Official records?
yes,
Okay. And is what you've brought here today an official record of the school that was in effect at Rich Neck on 2022-2023 school year?
yes.
Foundation has been established, you may proceed. Objection is overruled.
So I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes.
What page are you on?
18? And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
Yes.
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
Okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
Your Honor, I'm sorry, I need to pull that back.
10 seconds.
I'll provide it, Judge.
Thank you. All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression or has attempted to carry out threats in the past. Is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Parrish. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading Weapons Threat?
Yes.
I'm just going to ask you to read only that section that falls under the heading Weapons Threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon, evacuate the area, evaluate the perpetrator, isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Ferris. That's all the questions that I have for you. Please answer any questions from Defense Counsel.
Your Honor, if I may.
You may.
Still morning. Good morning again.
Good morning.
All right, a lot to unpack. So just to go over, again, you are the HR director
Yes, sir.
for Newport News Public Schools, and you conducted an independent investigation of this whole incident, is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that...
Objection. This goes beyond the scope of the direct exam and, is also asking about the investigation and other things that I didn't go into intentionally.
It was elicited on direct. That's one of the first things that she testified to, is that was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I was trying to figure out where the scope of objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, Your Honor.
And what part was your scope of objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all, Your Honor.
All right, okay. But if you claim to get there, I think he's going to object.
Well, we'll see what happens as we go along.
All right, you may proceed.
Okay. So you did conduct a complete investigation of this from the beginning of the incident to the end. Is that correct?
Correct.
Okay. And as a part of your investigation, did you view the videos that may have been taken, produced on Newport News School System's surveillance cameras?
Yes.
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
Not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Rich Neck Elementary School?
You want me to describe? You're not asking me how many.
I'm asking you how many. How many different positions, sir? Is it?
I don't recall how many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Rich Neck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways?
Yes.
Objection, Judge. We're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
Response?
I don't think I'm required to show anything. She's testifying, she's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response?
Your Honor, she's testifying as to what she observed. So, she looked at videos, she's testifying as to what she observed on these videos. So I'm not asking to introduce these videos, I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on those videos?
She is probably, I'm going to ask her to summarize what she saw in these videos, yes.
How is that admissible?
How is it admissible is something that she observed. I mean, she can testify as to what she observed.
Okay, so that goes back to his objection. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if the video is not admissible, how can she testify as to what she saw on the video? How would that also be, by analogy, admissible?
Obviously we have already submitted video into evidence.
Well, one video. Are you talking about that video or a different video?
No, I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events that they record. If I had the videos, I guess I can ask the court to take a recess so I can show her several videos that the Commonwealth just released.
Okay, 2 questions, or I guess 1 rule. Yes, she cannot testify to what she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming in through the Commonwealth's case in chief.
I understand. Is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay. So, again, my ruling is that she cannot testify as to what she observed on the video. I sustain the Commonwealth's objection. My next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object it, and the court can rule.
Yes, sir. And again, to the attorneys, I know that there have been a lot of objections, and there were a lot of objections yesterday, and squirrels all over, and sometimes I might be grumpy, but I'm not grumpy at the attorneys, and they are doing their job, so don't hold that against them. That was a cautionary instruction in the beginning. It is their duty to object, to make sure the rules are followed, and we analyze the rules of evidence. Okay, you may proceed, Mr. Rogers.
Okay. Other than Dr. Parker, were you able to determine the conduct of any other employees that were at Rich Neck Elementary on January 6th?
Okay, and don't answer. So, and your question was, she able to determine?
Observe the conduct, behavior of other parties, other staff members at Rich Neck Elementary School.
Okay, and in reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
Authentication, that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not producing. It's the same objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. If the court believes that she should not be able to testify as to what she observed by video, then I'm prohibited.
So I sustain the objection because it's the same thing we just discussed. And
Right.
again, if it can't come in through the front door, it cannot come in through the back door. Next question.
All right, I'll go to the, let me first talk about you being a custodian of records. Have you testified as a custodian of records for Newport News Public Schools previously?
Yes,
Okay. And so you're the custodian of this document, is that correct?
correct.
Okay. All right. If you'll turn to page 17 of this document.
Yes, sir.
Okay, it talks, I guess, about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive students in the classroom. Could you read that first paragraph, please?
Under the disruptive students,
Yes, ma'am.
the code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents should be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay. So would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection, that's improper opinion testimony. She's not been qualified as an expert to answer that.
Response?
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is, but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes.
Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge, this is getting into the findings of her investigation now, which is at the province of the jury to decide.
Wow.
And your response?
Your Honor, I'll submit that to you. I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I ask her to determine if something actually occurred or did not occur. That's not a finding.
Okay. So again, legal conclusions are a problem for the jury, but how is the finding of this school investigation not come, well, how is that not relevant and admissible?
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Parrish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it, and over the Commonwealth's objection, the court's rationale is the Commonwealth has introduced the school handbook, the policies, procedures, and the crisis management. And there's been a lot of evidence and questions towards was that followed on that day. So that's a proper subject for cross-examination. And the what the school found and all the school policies can come into evidence. We can have a curative instruction later if parties want that the school findings are not legal findings and legal conclusions for this case. And that is for the fact finders. And that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So if that supports the basis, I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. So, Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
Correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Swerner. So I meant Swerner. Could you answer the question in regards to Mrs. Swerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive, she could have removed him from the classroom. Is that correct?
Correct.
Okay. If Ms. West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right. So regarding the multi-hazard crisis and emergency management plan, this is a plan for each individual school. Is that correct?
Correct.
Okay. And are you, who's responsible for producing this document, if you know?
That will come under our safety security department.
Okay. Prior to this incident happening, were you familiar with this document?
I know that the schools have them, if you're asking if I'm familiar with this particular one prior to that incident. No.
Okay. And so you have become familiar with this document since this incident has occurred. Is that correct?
Correct. And when you say familiar, again, the custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
Through the entire document, no.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay. And would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes.
Okay. So this document would also apply to the teachers in the classroom? Is that correct?
Correct.
It would have applied to Ms. Kovac as a reading specialist, is that correct?
Correct.
Mr. Rawls in his position, is that correct?
Yes.
All right. And so, based on these two documents, was there anything in these two documents that prevented Ms. Swerner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No.
Okay. Is there anything in these two documents that prevented any of those four individuals, Swerner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
No.
So I'm going to actually go to the page 60 in the multi-hazard crisis and emergency management plan, which the Commonwealth directed you to.
Speak up for me, Mr. Rogers.
Okay. Did you hear what I said so far?
I heard you say you were going to go to page 60.
That's correct. Okay, and even when he directed you specifically to a weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, judge calls for an opinion.
Your Honor, this is the policies and procedures of the school. She's here as an agent of Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can ask you what does the manual say, but your question was whether or not it was applied or followed in the circumstance. So I'm going to sustain the objection.
Okay. So I'm going to ask it in a different way, if I may. Ms. Warner, Ms. Kovac, Ms. West, and Mr. Rawls, was it their responsibility to follow these procedures?
Objection, same objection. He's asking for an opinion of whether they should have followed certain procedures,
All right,
all of them or few of them.
Response?
I can rephrase it to make it more clear, I guess. Are they obligated to follow these procedures? And I'll let him say this objection.
Okay, do you object to that phrasing?
It's been asked and answered, but I don't object.
Oh, you may proceed with that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those 4 individuals, if they believe that there was a weapon, they should have...
Objection, Judge. This isn't the question that the court... He proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about that.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
State your question.
Was it their responsibilities when presented with...
Was it whose responsibility?
Ms. Warner.
That's the same question, yes, that I sustained objection to. Next question.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Ms. Ferris, Dr. Ferris, are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
Okay. Your Honor, I'm going to relinquish this witness to my colleague.
To your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Thank you, Your Honor.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have any authority that says they cannot. Understood. And I think you got something, Mr. G.
Oh, thank you. Good morning again, Ms. Farish. Are you Dr. or Ms. Farish?
Doctor.
Dr. Farish. You were shown a video of about 16 minutes earlier during testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting at certain sections.
Okay. So are you aware that the entire video was 28 minutes, or 28 or 29 minutes?
Based upon the timeline I saw,
Okay. And you were shown about 16 or 17 minutes, correct?
yes, as I recall.
And is it your understanding that the video clip that you were shown contains 3 different clips joined together?
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets, it's the whole video.
Okay. So I'm going to pull up the video, the actual video, the whole video.
Okay.
Judge, I'm going to object to this. I don't know what the relevance of this is.
Okay. And I'll give him a moment to respond to relevance.
I'm going to ask the counsel not put that up on the screen until we've addressed
That's
that.
fine.
Okay, he's objecting to relevance. What is defense response?
It's relevant. The witness has testified that she does not believe that the video has been cut up and, certain parts edited out.
Say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Okay. And what are you purporting to introduce and under what legal admissibility rule?
So best evidence rule, the Commonwealth has spliced the video, and he's cut out and skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Okay. And again, we agreed that the jury would get the whole video for deliberations. So your objection, and what you're going to play is a part of this whole video?
Yes.
Okay. And so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and that the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has, which they can certainly introduce evidence in their case, but this is still the Commonwealth's case.
So the legal principle here, when we start with my ruling, I'm going to allow it in over the Commonwealth's objection. The basis being, if the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth, the opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not a legally sustainable principle, does not comply with case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's this court's basis. You may proceed, Mr. G.
Thank you, Your Honor. And
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Understood.
Okay, the whole name, not initials.
Correct, the
Okay,
whole
fine, how are
name.
we dealing with that, Mr. D?
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid it.
We're talking about, again, audio and press coverage to the world.
I understand.
So
Yeah.
you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay, you may
But just to be safe, I'll just try to elicit the testimony from her directly, and then if I need to, I'll play the portions that I need to.
playing video or not?
It would just depend on her answers.
Okay, you might,
Okay.
okay, but understand, we have that
I
cautionary
understand.
instruction. We are not releasing the names of any minors. Okay, you may proceed.
Thank you, Your Honor. Dr. Farish, during the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to 2 other students that were acting out?
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I want to just refer back to my notes.
Dr. Parker was not just in her office ignoring the rest of the school during the testing, correct?
Objection, it's an opinion about something that she did not observe.
I'll rephrase the question, Your Honor.
Please do.
From Dr. Parker's testimony to you regarding the events of the day, she mentioned that there were 2 other student issues that she dealt with in the school, correct?
Objection, that was the most recent question. It's been asked and answered.
Response.
I want to narrow down and go down the path of asking about these 2 other.
Okay, repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Farish, of what was going on regarding her conversations with Mr. Kovac and Ms. Lerner, she also mentioned that there were 2 other student issues that she dealt with regarding misbehavior, correct?
Okay, hold on, that's the question. What's the objection, Mr. Jenkins?
This is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, you can ask it one more time. You can ask it, go ahead, so overrule.
Okay. Do you need me to repeat the question, Dr. Farish?
Yes, she responded to other issues.
Okay.
Students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Correct.
Okay.
Or a student who was an eloper. And
An
that's
eloper.
something that happened.
Right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
Correct.
Okay. Dr. Farish, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection, Judge, hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter entirely.
And her foundation for having that knowledge, her information, so sustained.
Okay. You interviewed Dr. Parker within 2 or 3 days of the shooting, correct? And she gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct? You also told her to keep the conversation confidential, correct?
Correct.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
A basis for your objection?
Judge, we're going to need to address this at sidebar.
Privately?
I'm asking her what she advised Dr. Parker during this interview.
I'm going to sustain the objection. Next question.
Okay. According to your interview with Dr. Parker directed Ms. Kovac to search JT's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay. So is it your understanding that Dr. Parker had been told that there was no gun in the backpack and also that he had been closely watched during recess?
Objection, can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
Sustain, can you rephrase to clarify what you're referring to?
Okay. Well, I've already asked the questions. I'll move on. Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
Okay.
Mind if I may? Yes. There is something in the background noise. I'm not sure where it's coming from. I don't know if it's somebody's cell phone or, but if we could try to take care of that, it's very distracting.
Yes, I keep hearing it and it's distracting.
Okay, well,
Yes.
the sheriff will be on top of that.
Okay.
And I'm hearing it to be, we'll work on it. All right, thank you. And again, it's 12:23, we're going to keep going. Again, we'll try to go till 1 for lunch, but do any of the jurors need a break? Okay, they indicate they're good. Okay, proceed with your cross.
Thank you. Dr. Parker also testified or said to you during the investigation that Ms. Werner never stated that the student had a weapon, right? And may I ask what you're reading?
It's a transcript of the video.
Okay. Do you have any independent recollection of
I don't remember her saying Warner said the student didn't have a weapon. I asked her, did Ms. Warner ever say she had concerns about the student and the student being a threat to her or her feeling unsafe?
Okay. Do you recall when the video was played here in the courtroom?
That's what I was trying to remember if Ms. Warner said that. I remember Ms. Kovac saying she did not see anything in the backpack.
Do you recall the video today where Dr. Parker was speaking to you in an interview and she stated that Ms. Werner never came to her and said that the student had a weapon?
Then, yes.
Okay. And everything that Ms. Werner related to Dr. Parker was about behavior of the student, correct?
Correct.
Okay. She also mentioned that they had, prior to this incident, that they had 2 incidents at the school where there was a potential weapon possessed by a student, correct?
You're referring to 2 other times?
Prior to January 6, 2023.
Correct.
Okay. And she also mentioned to you that they've never searched the student without the parents' consent, right?
That they've never searched students.
Okay. And she was also managing state testing that day.
Correct.
Okay. Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
Right. In fact, you came to the opposite conclusion, correct?
That is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
At any point, did you say something to go to? Oh, okay.
I just asked for a moment to refer to her notes.
Okay.
I do not recall making that specific statement.
Okay. But you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. He can ask her what she believes today, now, but not what she said out of court.
I thought you said during the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within this proceeding.
This proceeding.
Yeah.
She says that she cannot recall, she could not at that time recall making a statement, and I believe she believed I was asking her about the actual report itself that she created.
Okay, well then rephrase, because that's not the question as I understood it.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, hold on for the answer. So, assuming she says yes, which I don't know what her answer is going to be, are you going to ask her to then give that statement?
I just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
In your position, Mr. Jenkins?
He's feeding her the statement and just asking her to say, didn't you say at the civil trial? He's going to give her the statement and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly, to the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood, and your response to that, Mr. T.
Your
How
Honor.
is it admissible? What exception applies?
I can ask her about her statement. This goes to the foreseeable. You know what? I will try to question Your Honor. She's already answered that she has determined that it was not foreseeable. So I'll withdraw the question. Okay. No further questions.
Any redirect?
Yes, sir. Dr. Fish, much has been made about your investigation. Do you have, as part of your investigation, did you complete a witch neck investigation report?
Yes.
And do you have that report with you right now?
Yes.
May I approach, Your Honor?
You ain't?
Sure. I believe you have a copy. Judge, I've provided to the defense counsel a copy of the plan. Do I need to wait?
To review what you're presenting to the witness.
Of course.
To make sure that it is the same. Okay?
Very good.
Okay, you may approach.
Thank you. Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy?
Yes.
All right, so is that a fair and accurate copy of your complete, full report of your investigation?
Yes.
All right, Judge, I move to admit that as Commonwealth's 3, I think.
Your Honor, I'm going to object. This is the investigation, confidential information, like investigation report that contains hearsay from other parties. It's not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about, cherry-pick little pieces that they want to talk about, and I'm seeking to admit the whole document so the jury can see it for themselves.
Ms. T?
Your Honor, we are on cross-examination allowed to ask about anything we want to ask about. It's launched in the scope of the direct examination. This is a report that contains hearsay statements from other parties. Just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video, giving them a full report complete with hearsay is beyond the pale. It's not admissible.
Okay. Let me see the document.
Of course, may I approach the... Oh,
You may, yes.
the deputy has it.
Yes,
Yes,
please.
of course.
Thank you. All right. Appreciate you all.
Your Honor, I would add that Dr. Ferris has not been qualified as an expert.
the court will allow a redacted version in, so I will sustain the defense objections as to some of this are not admissible based on the rules of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in, the middle does not. I will remove the statement myself. And does the Commonwealth want the portion removed to be marked Commonwealth rejected?
Yes, please, Judge. Thank you.
Okay. Thank you. Grammatic Kirk is amazing. Commonwealth, this we're at 3. Commonwealth 3. Rejected 1. Rejected Commonwealth 1. Okay, you may proceed with your redirect.
Judge, may I retrieve Commonwealth's 3 from the court to bring to the witness?
Yes, and I'm going to ask. Let's say, well, yeah, I do. Your staplers work just as good as my staplers. You don't stand and make a mess. Oh, here you go, sir.
Dr. Parrish, for the purposes of these questions, I'll just ask you to refer to Commonwealth 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the 2 that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Your Honor, again, I'm going to object to hearsay. Those are statements coming from other people.
You asked for the finding to be in evidence, the findings in evidence. So noted your objection, overruled.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Mr. Werner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause: failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll retrieve Commonwealth 3 after you and return it to the court.
Thank you.
Now, Dr. Parrish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes.
All right, and that document is an authentic manual that provides all the policies that were in place at Rich Neck in the 2022-2023 school year?
The Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district?
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth Court. I will have to retrieve it from the witness.
Okay, you may approach.
Your Honor, before that's admitted by the court, could I have a moment, please?
Yes, sir. You can still retrieve it, Mr. Jenkins, and you can pass it to Madam Clerk. I won't receive it until I get from the defense counsel.
The court already ruled that it would come in, so.
Oh, all right, so this will be marked Commonwealth 4.
May I approach the witness, Judge?
You may.
Dr. Parrish, could you take a look at what I just handed you and identify it?
Yes, this is the Newport News Public Schools, Rich Neck Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of the same document that you have that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in whole, unredacted, as Commonwealth's 5. May I approach the witness?
You may.
I just want to make sure our objections no continue.
Yes, continuing objection, which was previously ruled on and for the record was made contemporaneously.
And I have no further questions for the witness, Your Honor.
Thank you. Any recross?
Yes, Your Honor.
Okay, briefly.
Briefly, Dr. Ferris. Again, the portion of the report that was just entered into evidence, your investigative findings, you were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving up any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
You also mentioned in your root cause section of your report a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct?
Correct.
And according to your report, all of the, I'll just name them specifically, Ms. Werner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker, your finding is that none of them responded adequately, correct?
Objection, Judge. I think that misstates the evidence.
To respond adequately, I do think it's a misstatement. Can you rephrase?
Okay, all right. In your root cause section, you write, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named? Ms. Werner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims, and Dr. Parker?
Yes.
Okay. No further questions, Your Honor.
I have a follow-up, Judge.
Yes, sir.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically?
That was the one.
We took it away from you. Can
That's okay.
I please retrieve Commonwealth's
You may.
the Rights and Responsibilities Handbook. And I can give you a page cite. I'll direct your attention in Commonwealth's 5 to page 28, the paragraph that begins principals and school security officers.
Principals and school security officers, under the direction of a school administrator, may search students and student property.
All right. So, given the root cause analysis that involves the failure to search, who is authorized by the district's rights and responsibilities to search?
The school, under the direction of the school administrator.
Okay. And are teachers that work in a school considered school administrators?
No.
Are reading specialists that work at a school considered school administrators?
No.
All right, thank you. I don't have any further questions, please.
Okay, so this, so that paragraph, it starts out principals and school officers, and then it, comma, under the direction of a school administrator.
Objection. I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
Are you reading the same thing the witness has?
Yes, ma'am.
Okay, then go ahead. You may proceed overruled.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes the principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of a school administrator.
Principals? Okay, so if I take out, it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that seems to indicate there needs to be some authority above the principal. Do you disagree with
The
that?
same, Mr. Jenkins, the same. Next question, Mr. Rogers.
That's all I have, Your Honor.
Okay, the status for this witness. May she be excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to leave.
Mr. Rogers?
Yes, Your Honor.
We concur. Okay, all right, so Dr. Fair, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room. You can go about your day, be available by phone if we need to call you back for your testimony.
Yes, sir.
Okay, and you'll be informed when you receive frustration ends and when you're released from the witness obligation. Okay, thank you, ma'am, and what I accept that you stepped in.
Thank you.
All right, can we do another witness in about 10, or start with another witness about for 10 minutes or so? I want to use up our time.
Before we call another witness, I would need to step out, so.
Okay, yes, Mr. Jenkins.
if we're going to need to take a break here, it doesn't make sense to call. The break will take 5 minutes, and then we'll only have 5 minutes of a witness before
Okay,
one
so
time. So
it is 12:51. We will start our recess for lunch. For the attorneys, are there any motions, objections that we need to take up before we resume evidence? Meaning, I'll tell the juries to report back at the jurors at one time, and I'll tell you all a different time if we need to work out issues.
there's nothing from the council.
Okay, so I'm going to keep a tight schedule. Jurors report back at 2, attorneys report back at 2, and we'll get going. And there should be lunch back there. Again, jurors, your recess instructions. Do not discuss the case. Do not research the case. Do not allow anybody to discuss it with you. I will check it when we return. You are welcome to leave the building, where I think we have Subway for you today, if you wish to partake, or of your own lunch. All right, Sheriff, you'll escort them to the jury room, and we are in recess. Thank you.
We draw to the jury.
And the media can come and turn on their audio.
Michael Ray. I represent your mother. First off, you were interviewed by Detective Hayes on July the 5th, 2018, correct?
Yes,
Okay.
that's correct.
So that would have been the day you came down from Tennessee. Where was that interview at? Was it at the Free Home Precinct or was it at the house?
It was actually at the barn on the property. So it was on the property, but it was at the barn.
Okay. So still on the property?
Yes.
Was everybody else still on the property?
Yeah, everyone
That
was
be,
there.
you know,
Yeah.
Scott, Chris, Melody? Okay.
Yes.
Amanda, Chad?
I don't know if Chad was there at the time, but Amanda was there.
Okay. And I'll go ahead and tell you, because your interview, your direct, the order of it, I'm going to have to kind of jump around, okay? So if I confuse you, just let me know. You were calling that interview to tell Detective Hayes that you knew perfectly well that your parents lived in separate rooms, correct? Slept in separate rooms?
I knew that they slept in separate rooms, yes.
In fact, you actually told Detective Hayes that you found your parents' relationship odd.
I did.
You also, he had talked to you about any history of violence between your parents, and you recall telling him that you never even really saw them argue anymore, correct?
I don't know if I said that. I've never seen any physical act of violence between my parents.
Do you recall telling him that when they get upset with each other, they just don't speak to each other?
Yes, I would believe that I would say that, yes.
And also, in fact, that you said that essentially for the past, at this point, at least the past decade, they essentially lived as roommates.
I don't know if I would call it roommates. I think that they slept in separate bedrooms, but I mean, their clothing were still, like, they still had closets in the master bedroom. I mean, my mom had closets of clothes all over the house, but like, they still went to the master bedroom to get dressed. I know my dad still used the master bathroom. My mom used the bathroom upstairs to get ready, but, you know, she had like a ton of stuff, so, I don't know if roommates is the best, but yes, I mean, they were still contentious with the fact that there was a rift in the marriage.
Okay. We'll come back to that in just a minute. You don't recall any money issues between your parents, or your father did not have any money issues to the best of your knowledge?
No.
Were you aware of the level of financial support your parents had to give Chris and Scott?
Oh, yes, I was.
And Gary helped you out too as well, right? Not to that level, but...
Not to that level, no. Yeah.
Because he co-signed on the house for you. He also helped you with the condo prior to moving to Tennessee?
Condo,
Apartment?
I paid my rent for my apartment in Atlanta, if that's what you're asking.
Okay, did Gary ever pay your rent?
No.
Okay. Did Gary ever pay your utility, cell phone, insurance, anything like that?
I was on our family plan for cell phone,
Okay.
And then I decided to go on my own account. I think that was like in 2012, I want to say. But I did actually separate from my family's cell phone plan.
Okay. Did you know that essentially Chris's entire utilities were paid by Gary?
I was aware of that, yeah.
And did you know essentially Scott's entire living existence was funded by Gary?
Yes,
Okay.
I knew that.
And did the whole family know that?
Yes, I mean, yeah. We all knew that for
Okay.
sure.
And did you have any access to, did you have a Gary credit card or debit card?
No,
Did you have access or know any of his account information?
I did not, no.
Okay. And kind of just jumping around, on the 5th when you got here, you had a conversation with Chris where you had to loan him $20 so that he could leave.
Yeah.
And I believe you had to loan him that $20 because he stated that he had bounced a check and his accounts were overdrawn.
I don't know why I assumed he just didn't have the cash, but I don't know what happened, why he needed it from me. He asked if he could borrow some cash, and my husband went to the ATM, got some out, and gave it to him.
Okay. See, but you don't know what he was using it for?
I assumed just to get home.
Okay. kind of just jumping around. So all the kids knew about Ted Wiley around 2008.
Yeah.
Okay.
around
And
that
at this
time.
point in time, Chris is a grown man, right? In 2008.
Yeah, yes.
So is Scott. Okay. I think you're in college at this point, right? So
I am, yeah.
You're grown. And I think Amanda's in college too.
Yes.
Okay. So all children are now adults on their own.
Right.
Okay. Now, you had told on direct examination, I think that Chris is the one that told you about Ted Wiley?
No, my
no,
dad.
I'm sorry. That Gary had told you directly about it? Okay. And what did he called and told you that?
He did.
Okay. And then you had went through, and you had talked about this account where Melody had taken money out that your father told you about, the HELOC account. Okay. Are you aware that it's around this point in time that Gary had actually filed for divorce?
I don't think I knew that he had filed for divorce, like leading up to it or when it was happening. I think I found out about that like later on. I don't think I knew in the moment that he had filed for divorce.
Did you know that Melody taking the money out of the account coincides with being served with the divorce papers?
I probably don't. I couldn't tell you exactly when she did it or exactly when he filed for divorce, so I don't know if those happened together.
Okay. Regarding the money, do you know, did Melody just take that money when her and Gary got back together, or she put it back in the family account?
She did not return it, no.
Okay. And did your dad ever tell you what happened to it?
No, she just didn't give it back.
Okay. Gary, do you know where it was?
She did say, I did ask her if she still had some of the money left, and she said she did have a little bit of it left, but I know my dad said she never returned it. He said that several times.
Okay. And that account, because you called it a HELOC account, it wasn't like she went and took out a mortgage, it's just money in an account.
No, they had the HELOC. They had it already open with the house that they were in, so it was like something they can draw from.
Yeah, so you can pull money out. It's not like going to
Correct.
get a new loan.
Right.
Because your mother wouldn't qualify for a loan because she was a stay-at-home wife.
Right.
Okay. Now, Rusty being at your wedding, I'll show you. Megan, you turn it off. So Rusty was at your wedding, and you knew who Rusty was previously, right?
Yes.
You knew who the person was. All right. And I believe you testified on direct examination that I want to make sure I got it correctly, that essentially that your dad was devastated.
Yes, I mean, he was very upset.
So your dad's devastated at your wedding, and I'll show you what's marked as pane 10. Your devastated dad is standing directly next to lighting a sparkler with Rusty Barton. Okay, good. And he's devastated at that point.
I would say he was probably more devastated. My dad was a very selfless person, and he would not have been sulking around angry. He would have never made a scene at my wedding. So my dad, I think, at that point, with how much they had gone through with all like this stuff, I think that he was able to like compartmentalize things and focus on the event, what was going on.
Okay, but you would agree with me, even if he's not wanting to ruin your wedding, which I would agree, I don't think any father would want to ruin their child's.
Right.
Especially their favorite child. I think everybody agrees you're Gary's favorite, just so you know.
Okay.
He doesn't have to stand next to the man you supposedly believe is devastating the wedding, right?
Yeah, no, when I saw this picture, I thought that was weird, for sure.
All right. By the way, when was your wedding? What year?
2016.
2016.
July of 2016.
July?
It was in July.
July? Okay. All right. So 2 years before Gary's passing? Because he passed
Yes.
in 2018?
Yes.
Or that's when the remains were found? All right. So you had talked a lot about how you didn't want Rusty being at the wedding, right? Okay. And you said something interesting, I thought, that you couldn't do anything about it, essentially, and I'm paraphrasing here, because Melody would cancel your wedding.
I believed that, yes.
Okay. Now, you also testified previously that after the whole Ted Wiley situation, that your dad had changed all the accounts and took Melody's name off. Right? That's what you testified to. All righty. Melody didn't have a job. She was a stay-at-home mom, right? Okay. Gary's the breadwinner. If any of y'all need money, who do you call?
I mean, both my parents, but
Who's got the money?
my dad has.
I mean,
my dad has
they're married.
accounts,
It's
right.
their money, but
Right.
it's Gary's money, right? He's the one making it.
Right.
Okay, so-
He is the income.
Okay, so how can Melody cancel your wedding? She doesn't even have a credit card.
She has a lot of influence over everything, especially my dad. I mean, even though my parents were having a troubled marriage, I would say, he listened to her and did not want to upset her. And if she said, Gary, don't do this, he'd listen to her. He would do absolutely everything that she said.
You're telling this jury that the man who removed his wife from all financial accounts and, according to the state, controls every ounce of her spending, still listened to her and would do what she wanted him to do?
Absolutely. Yeah.
Okay.
That happened, when that happened with Ted, that was many years before, and I think, he did it in an emotional reaction. But my dad spent a majority of the years later trying to get her back, essentially, trying to make her happy, and she still got everything she wanted. It wasn't anything like that, but yes, if my mom said, don't do this now, he would have listened to her.
Okay. Well, that didn't work with your house.
I'm
It didn't.
sorry?
That didn't work with your house.
What do you mean?
When he went on there to get on the mortgage, you said Melody was all mad about it for
She was
whatever
angry.
reason.
She was angry, and
And he still did it.
that is because she said that the only reason she would agree to it is if she's added to the title of the house as one of the owners. And in the moment, I agreed to it because I was in a tough spot, and that's what had to happen. And I told my husband, we will refinance a year from now, and we'll get it under our names. So she agreed to it, but that was the terms of her agreement.
Yeah, and you had mentioned on direct, there was something about some Tennessee law where your spouse had to know.
I didn't know about that, but apparently that's something like our broker had said to us, that in Tennessee, when one spouse buys, I guess, real estate, the other spouse has to sign off on it.
Okay. Growing up, did you ever hear the name Angela Phillips?
Yes.
Okay. Did you realize that was your father's longtime assistant?
His secretary, yes,
Yeah.
the secretary.
And she had actually moved from Alabama to Atlanta.
I don't know. Honestly, I was so young, I didn't know if she came from Alabama, but sure.
Oh, that's right. Because in '95 when they moved, you'd have been like 6 or 7.
Mm-hmm.
All right.
Yeah.
So,
Or 8.
but you remember seeing her in Atlanta, right? But when y'all lived
She
in
would
Alpharetta.
she would be at the office when we'd go up there to visit my dad. And then there would be times where Angela would kind of like babysit us. She'd come into the house and watch us while my parents were doing whatever they needed to do. Yeah.
And you had no idea that your father had at least somewhat of an affair with Miss Phillips.
I have no knowledge of anything like that.
Okay. And just so I'm clear, Amanda and Chad, they were both at the wedding, right?
Yes, actually, my wedding weekend was the first time I met Chad.
Because I know you stated at one point that Amanda was extremely upset, right, at the wedding,
Yes.
right? All right, and we'll agree that, so that's Rusty, right?
It is.
And Chad,
Yep.
and they're just sitting there drinking beers.
Mm-hmm.
Chad's Amanda's then boyfriend, now husband.
Mm-hmm.
Okay. Now, you married a man named Chris Payne?
That's right.
Yeah, 2 Chris's in the same family. That gets confusing.
It does.
Trying to read my own handwriting. Just give me 1 second. Oh, so your daughter was born in 2017. Melody came up there, and I think you actually said stayed a few weeks with you.
Yes, that's right.
Stayed in your house?
Mm-hmm.
Okay. I know Gary had come up to the hospital. Did he leave after that?
He did. Yeah, he stayed for a couple of days. I think he left the day that I was to be discharged. I think it's when he went back home.
Now, I want to, I'm sorry I'm having to jump around like that. This is that message that Ms. Frankus was going over with you. This was sent on July the 2nd, and then about Chris charging money and all that stuff. In a trip you weren't going on, so you probably didn't care about. I'm assuming that's why you didn't respond. Then Ms. Frankus didn't go over the following messages, which is on here, and this is pane 11, July the 4th, 2018. Melody has sent you, I Missed a Little Princess. You see that?
Yeah.
Okay, I'm assuming that is in response to the photograph that you had sent of Olivia.
That's right.
Okay. And so that was at 8:15. And then the following day, because you had kind of bounced around on direct between, who calling and texting when everybody was looking for Gary. But you can see here, July the 5th at 12:23, Melody had texted you and said, "Call me ASAP." Okay. So, and if that was 12:23 here, that would be 11:23 your time in Tennessee.
Right.
Okay. So that kind of makes sense. So Melody texted you, and I'm assuming you would have called her back, and that's when she would have said, "We can't find your dad." Okay. Now, who out of your two brothers, who are you the closest with? Chris?
Probably, yeah,
Okay.
Chris.
I want to ask, just because, I'm trying to figure it out, with the whole Gary birthday, Father's Day celebration thing, in these text messages, you're a little upset about with Scott, alrighty? But then you're also testifying that Melody had something to do with it.
Yes.
So what my question is, well, first off, because there's multiple Chris's. So who's going to smoke the food? Your Chris or Chris Ferris?
My brother, Chris Ferris.
Okay, so Chris Ferris is going to smoke food at Purcell Lane. That was your plan. And then the plan just kind of changes, or for whatever reason, and Scott's going to smoke the food. Okay, who cares? Why is that such a big deal?
I just thought it was rude that my brother and I were planning to do these things. We thought was a nice gesture for the family, and it seemed like we were trying to get roadblocked.
Why are you there? Why are you... why are you dating? Why are you throwing Scott and Melody in together? There's no indication of any of that.
Well, she went out and bought Scott a brand new smoker. I mean, I just thought I thought it was very, I just felt like, I don't know what I'm trying to say.
No, that's fine. I'll move on. Moving to the episode that Gary had. So if I understood it correctly, somebody called you, said Gary's real bad, and then later on Chris calls you and says, no, he's actually fine, and you just thought that was strange. That sum it up?
I mean, I thought it was strange that my mom was making it sound like he was at death's door, and then I hear from my brother, and it's not as heavy as of a situation as I thought it was.
Okay. Would you be surprised that Scott testified in being one of the people that took him to the hospital of how bad he actually was?
No, I mean, I'm sure he was bad. I mean, if you're wanting to go to the hospital, I would imagine you're probably not in good shape.
Yeah. And it was only just because he had gotten some treatment, and then when Chris got there, he was feeling better.
Possibly.
I mean, that would kind of make sense, right? And,
Sure.
When you get lucky, when you go to the doctor, you feel better.
Right.
Now, out of your two brothers, which one are you the closest with?
Probably Chris.
Well, let me ask you this way, too. You and Amanda, are y'all fairly close? Were.
We were, yeah. I would say that once Amanda and I got into college and then into our young adult lives, we definitely got closer.
Okay. So, but out of the two boys, you're probably closest with Chris.
I mean, at that time, I would say I was probably closer with Amanda at the time out of all the siblings. But ever since this, yes, I have grown significantly closer to my brother Chris and Scott.
Okay. How often would you say that you speak to Chris and Scott?
I would, sometimes we'll go through stretches where Chris and I will talk like every other day, and then there's times that we don't talk for a few weeks. And then Scott, we probably talk about once or twice a month,
Okay. How much have you talked to him? How much have you talked to Chris, let's say, past 2 weeks, since this trial's been going on?
The past 2 weeks?
Yeah.
Pretty
Since
often.
beginning of October.
Yeah, pretty often.
Every day?
Sure.
How about Scott?
No. Maybe every other day. Yeah,
Okay.
pretty often.
Have you talked to him since they testified here today?
Just because, yes, I'm staying at my brother Chris's house, and Scott is watching my kids today, so yeah, I have talked to them.
Okay. Did they talk about what they testified to?
No.
Say it again? They did not?
No.
Okay. All right, moving up to around July the 5th. There was a lot going on back and forth with the whole bullet issue.
Yeah.
So who gave you confirmation that there was a bullet?
Manny Aurora, the attorney that was representing my mom at the time, he called me and told me.
So he called you?
He called me with the confirmation, yes.
So you didn't learn that from Detective Hayes or any of your brothers?
No. The first time that I heard of a bullet was from my brother Chris saying that he had received a call from Detective Hayes saying that they had found a bullet in the rib. But like I said before, we didn't have any kind of confirmation from any kind of professional. It's not saying Detective Hayes isn't a professional, but just saying we didn't have we just didn't have the confirmation at that point, I guess.
Okay. You had also, you were talking about with Miss Frankish, saying that Melody was demanding money back from y'all.
Yeah.
Okay. But you also said you had some kind of loan with your father?
Mm-hmm.
Okay. How much was it?
It was I think it was $3,000, yeah.
Okay, $3,000. Were you paying him back?
The plan was to pay him back, yes.
Okay. When did he give you that money?
It might have been May of 2018, I want to say. It was early summer, I think it was, when that happened.
What was it for?
My husband needed to hire an attorney.
Okay. Mm-hmm. Okay, so it was for legal counsel.
Yes.
All right, for your husband. All right, and I'm assuming, because you said that was the plan to pay him back, you had not started repaying him.
No, in fact, I was supposed to make the first payment to him in July.
Okay. Well, when you were with this supposed conversation you had with your mother, mm-hmm. do you recall telling her that you had this loan with your father and you're not going to repay her?
I did say that in anger. I did say that to her, that I wasn't going to, I had it with him. I wasn't going to pay her back. I was with him, but that was kind of in the moment. I think I just reacted in a hateful way, I should say.
And you'll agree, because Garrity, I've lumped them together. Gary and Melody, they're married, right? It's theirs, right? Mm-hmm. Just like you and Chris are married. Mm-hmm. So what's Chris is yours and what's yours is yours.
Right.
That's what my wife says.
Right.
Okay. So, you can understand her saying, hey, repay the debt, right? Mm-hmm. Okay. Moving up to this whole Sally Sims thing, what kind of letter did she send you?
I probably still have it at home, but it's just kind of recording his birth and death date, and that he was deceased.
Okay. Why would the coroner or deputy coroner? Why would she send that to you?
I was communicating with her, just trying to see if we got any updates. I wasn't reaching out to detectives, just to kind of respect her attorney at the time's wishes. But I felt comfortable reaching out to her. She was so nice, and she always said, if you need anything at all, just reach out. And so I don't remember requesting it. I think I was just talking about the issues that were coming up with not having a death certificate, and she offered that to me.
Okay, basically as a compromise of, we don't have a death certificate, but I do have it.
Right.
And because it was it's 11 months and some change before the actual autopsy was released. Were you aware of that?
I don't know dates like that.
Okay. One second, Judge. I just got to look up one thing real quick. No further questions, Judge. Redirect.
I don't have any redirect.
All right, you sit down. Thank you.
Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Okay, have a seat, and please introduce yourself to the jury.
I am Sally Sims. I've been county coroner since 2020.
And Ms. Sims, before you were the county coroner, what was your job?
I was a deputy coroner for Forsyth County and deputy coroner for Earl Darby, our Cherokee County coroner.
In 2018, what was your job?
I was deputy coroner for Earl Darby.
Ms. Sims, without telling us your address, what road did you live on at the time in 2018?
Literally less a half a mile from the house.
From the Purcell Lane house that we're
Correct.
talking about?
Yes.
Okay. And so, can you tell the jury about how you were called out to 2155 Purcell Lane on July 5th, 2018?
I was dispatched by our internal call system back then, before we went through dispatch, and I was told that a decedent had been found in the fire pit. So I got dressed and got my vehicle and put the address in, and it was just down the street. So I was there and met detectives.
About what time did you arrive to the house on the 5th? And if you have to refer to a report, you're more than welcome to.
I believe I was dispatched at 13:15, so it would have been probably about 13:30, I believe.
So is that 1:30 p.m.?
Yes.
And what did you see when you arrived at Purcell Lane?
I met detectives down the driveway, and we walked down into the backyard, and there was a burn pit, very large burn pit back there. And I stepped around Detective Kuykendall and saw the remains.
Ms. Sims, I put up State's Exhibit S Ferris 11. Is that the property of Purcell Lane, 2155? Purcell Lane?
Yes, ma'am.
Scoot it just a little bit and pull the mic in front of you.
So when you arrived, so the driveway is over here,
Yes.
right? And then there was another driveway up to the barn. Where did you pull your vehicle in?
Just at the top of the driveway.
And which way did you go around to get to the burn pile?
Around the left side of the house.
So if you're parked in the driveway, you walked around the left side? I guess this would be the left side.
Yes, as you're facing the house, I went to the left.
Okay. So by the chicken coop, did you pass the chicken coop when you walked through there?
I don't remember seeing a chicken coop. I was looking down.
Sure. So when you arrived at the burn pile, what did you see?
When I looked around the detective, I saw it was still smoldering, and I could see a partial skull, partial mandible, a femur. I think that was it.
What was going on through your mind when you saw those remains?
Immediately, I backed away, following my own footsteps backwards, that this was not a decedent that had fallen in the pit that day.
Was that the information that you were provided prior to arriving?
No.
Okay.
What was the information you had when you arrived?
Can I look at my notes?
Yes, ma'am.
It was that his son had found his father in the burn pit.
Okay, that was the only information you had.
Correct.
But at that point, when you saw the burn pile, you had no idea how long the body had been on that
No.
fire. Okay. So, what were your duties on scene that day?
I need to secure those remains as evidence.
And how did everyone go about doing that?
We actually backed out of the scene, went back up to the top of the driveway, and they obtained search warrants.
When a coroner or a deputy coroner is called out to a scene, what is your duty? What is your goal? What is your role on scene, generally?
I secure a decedent, and then I talk to the family about history, what happened, how they had been feeling days before. I make the determination of whether they need an autopsy or that they can go to a funeral home. I make decisions on whether I need to subpoena medical records.
Did you do that in this case?
Yes, ma'am.
Did you speak with the family members on scene personally?
Not initially, no.
At any point, did you
Yes.
speak with family members? Around, when was that? The next day, the same night, or a week later?
It was a couple of days after to a week later, I spoke with Ms. Ferris on the phone.
Okay. The defendant?
Correct.
So what was determined, based upon the state of the remains on scene, what decisions were made that assisted you in securing the remains?
Initially, when I saw what I was dealing with, I initially thought we should probably get the anthropologist out, and I had been down at GBI, I guess a couple of months before, and had listened to her speak.
Her being Dr. Gooding?
Dr. Gooding, yes.
So did she eventually arrive on scene?
Yes.
And did you assist her in securing the remains?
Yes.
And did you follow sort of her lead on that when it comes to process and procedure?
Yes.
At any point, did you see a projectile in that burn pile?
Yes.
Can you describe that to the jury, please?
As Dr. Gooding was handing me the remains, I was putting them on a gurney that had a sheet and our body bag down there to secure them, and she handed me an object, and I looked at it, and I looked at the other detective, and I said, "Is this what I think it is?" And he photographed it. I believe it was around dusk by then, and he photographed it, and we both looked at it very closely, and he said, "Go get Captain Pinion." And I did.
And what happened after that?
Captain Pinion came down, took a look at it. Everything from my point of view, Dr. Gooding and I were still continuing to do our job.
You just let the authorities know and continued to work?
Absolutely. They secured the projectile, yes.
Around what time, or how many hours were you on scene that evening? Do you remember?
I think I began around 1 o'clock or 1:30, and I think it may have been like 12 midnight, I think.
Once the remains were secured, what did you do next?
We took them back to the morgue, secured them in the morgue. I called GBI and told them what we had, and they accepted the case, and I think they were transported by another deputy coroner. I think it was the next morning.
How does that assist with your role? Once you're off the scene and the remains are secured, what is the next step in your role as the deputy coroner?
I report to GBI. I start subpoenaing all medical records that I can. I talk to the detectives and see what else they need. And once I start getting medical records, I go through those and see what else we need to obtain. And generally, I talk to the families.
Tell the jury about your conversation with the defendant that you mentioned earlier?
She would call, it was either on Tuesdays or Wednesdays every week, just to see how the case was going, to see if I had any updates.
When was the next update that you were able to share with anyone in the family?
I actually didn't share any updates. I think I spoke to the daughter at one point. They were trying to obtain death certificates, which I could not complete until we had a full autopsy report from the medical examiner's office.
When did you obtain the autopsy report?
I believe Dr. Atkinson called me a couple of days later and described what he had found. And I didn't do the death certificate. I think it's for a couple of months, I think.
And why is that?
We were still obtaining evidence and information.
The phone call that you received from Dr. Atkinson, was that his formal report?
No. Mostly medical examiners will just give the coroners or a deputy coroner a report of what they found and what they were going to proceed with and how we were going to go about it.
When you were at the burn pile, did you take note of how hot the burn pile was on either side?
Yes.
And what were those findings?
It was the fire chief that did that. The heat was 230 degrees on the right side and 86 degrees on the left.
So did that prepare you for what measures to take when you were obtaining the remains out of the pile?
Correct.
And what did you have to do?
Well, Dr. Gooding got on scene and we had to grid it, and obviously the detectives helped her also with crime scene. So it was gridded and flagged, and we just had to be careful of the heat.
Now, you lived very close to this property. You noted some things that you had observed prior to and the days leading up to this. Can you tell the jury about what the weather was like the days prior to finding these remains?
So my house is kind of kitty corner across here, and usually I had 2 horses down the barn, and it was 4th of July, and the people behind us were always setting off fireworks, and I could smell burning. And I told my husband, can you just walk down to the barn and make sure there's no fireworks or anything, everything's good down at the barn. And I was standing outside in the driveway, and he came back up and said, I don't smell anything down there. And I thought to myself, it's coming from the left side, which I had never smelt anything from the left side. Usually it's from behind. So I was like, oh, somebody must be burning things over to the left, way left. And that night, I remember we had isolated like rain showers because I was happy. I didn't have to worry about the horses with the fireworks.
And that was on the 4th?
Yes.
And when you say the left side, what direction is that?
Let's see, that would be south, north. It's the north from the Forsyth County line.
Is that in the direction of the Purcell Lane property or a different
Correct.
direction?
No. In the direct, like 11 o'clock. If I'm standing in my driveway, it's 11 o'clock, the Purcell house.
When you are called out to a scene and you have to gather information to determine how an individual passed, is that accurate?
Yes.
You receive a lot of information from, let's say it's an investigation. You receive information from the
Yes.
investigators to make that determination?
Yes.
Okay. Ms. Sims, I want to talk to you about a little bit of your experience as a coroner. You deal with a lot of dead bodies.
Yes.
Okay. And have you dealt with individuals more than 250 pounds?
Absolutely.
Have you been able to maneuver those individuals on your own?
Yes.
How so?
I mean, we can put slide mattresses, you know, we have sliders that we can put them on. It depends whether you're moving somebody from a bed or whether you're moving them from a floor. You can put tarps under them to move them out from where you need to be. Obviously, in most cases, I do have the officers help me.
You do have help. But you have done it before on your own?
Yes.
Just 1 second, Your Honor. When you were around the property that evening, it had rained, you said, on the evening of the 4th.
Yes.
So you were out there the evening of the 5th.
Yes.
Did you notice anything on the property, any tracks or any marks or anything like that on the Purcell Lane property?
Yes.
What did you notice?
There was a Kubota in the backyard, and there was track marks from the Kubota.
Was it like a tire mark?
Yes.
And did you point it out to law enforcement?
Yes.
Okay, that's all I have for you. Thank you.
Thank you.
Mr. Ray.
Good afternoon, Ms. Sims. My name's Michael Ray. I represent Ms. Ferris. First off, I want to show you what's already been admitted, because you were talking north and south, so I wasn't quite sure, okay?
Absolutely.
So, what was previously admitted as Aerial 2.
Is there 372? Does it show Highway 372?
Okay, you see Aerial 2 here? Can you see it on your screen?
Yes.
Okay. Because you were talking about you spelled something. Where are you at? On the 4th.
In my driveway.
I know. Where is that? None of us know.
Well, it's off of 372.
Off of 372?
Highway.
Okay. In this photograph, can I see your house?
I don't see my house.
Okay. So it's none of these houses here, right? Let me make it easy for you. This is Hickory Hill Road.
I am not on Hickory Hill Road.
This is Hickory Hill Court. That's not you,
No.
right? All right. This is Purcell Lane. That's not you.
Correct.
Okay. And in this entire photograph, I can't see your house.
You are correct.
Okay. But you're saying you live close enough to the Ferrises that you can smell burning.
Correct.
Okay. How far do you live away from 2155 Purcell Lane?
I'm on the left. I'm off of 372.
So you're north up on like Birmingham Highway?
South on 372.
Okay. So
When you come out of Purcell Lane, go left.
okay. Like, is that a mile away?
About a half a mile.
About a half a mile away. Okay, and you're standing in your driveway, and you can smell something, and you're sitting here telling this jury that you think it was coming from Purcell Lane, a half a mile away. Can you even see their house?
Cannot see it, no.
Okay, so you're just looking through the trees being like, that must be 2155 Purcell Lane burning something.
No, I can smell it from that direction.
Okay. Did you know when you went out there that now you've not only there as the coroner, but you've also made yourself a witness in the case?
Correct.
Did you notify anyone of that?
The detectives?
Okay. Do you think they put any of that in any of their reports?
I wouldn't know. I haven't seen their report.
Okay. I think we'll be asking them about that later. Didn't you think that it would be important if, hey, I may be a witness in this case, maybe I should let the elected coroner know?
Earl Darby, coroner, was notified.
Okay. Is that in your report?
No.
Don't you think it would have been prudent at that point in time, since you may also be an eyewitness, that another deputy coroner should have been out there at the scene?
I'm sorry, can you repeat that?
Since now you may be a potential eyewitness in the case when you get there, that possibly another coroner should be there who is more independent.
Another deputy coroner was there.
Who was that?
Blaine Ross.
Was he working in the fire removing the remains with you?
He was.
Who was in charge of Mr. Ross? You, right?
Yes.
Okay. So, you arrived at 1:30, right?
Yes.
Or 13:30, I think is what your report
Yes.
says. Now, you just stated on direct examination that Dr. Gooding handed you remains.
Yes.
You took those remains and were looking at them, right?
Yes.
And you observed what you believe to be a projectile.
Yes.
Okay. Are you the first person who saw the projectile? As far as you know.
Besides Dr. Gooding, yes.
Okay, so Dr. Gooding saw it first.
She handed it to me, yes.
Well, that's what I'm saying. Is she handing you remains and just being like,
She's
"There's
hand-
more remains coming," or, "Hey, this is extremely important, there is a projectile in this remain"?
No, she was handing me remains.
Okay, so you don't know if she saw a projectile in the remains.
Correct.
Okay. You testified that there was a detective there with you when you saw the projectile. Do you recall who that was?
Call him OJ.
Is it
Detective
like
Olin.
Oh, yeah.
Yes.
It starts with an O and it's
Yes.
last name unpronounceable. Okay, it's him?
Yes.
All right. Do you know a Detective Westbrook?
Yes.
Okay. Detective Westbrook previously testified that he's the one that found the projectile. That wouldn't be correct, would it?
I was handed by Dr. Gooding, so if he was in the grid with her and Detective Shaw, then yes, he would have seen it.
How far apart is Gooding from you when she hands it to you?
Several steps.
Several, okay. More than 10 feet?
No.
Okay. So relatively close, right?
Yes.
All right. Can she actually hand you the remainder, or does she have to like pick it up, walk it to you, and then hand it to you? Or can she just pick it up and hand it to you?
No, I think she walked to me.
Okay. Few paces?
Yes.
Okay. Now, once you had all of the remains back, you stated that you took those to your office.
We did, yes.
Okay. And where they were secured at that point in time?
Yes.
And then it was the following day on July the 6th where they were transported to the crime lab, correct?
I believe it was, the day after.
Now, you were talking to Ms. Frankish on direct that you had a phone call with the, was it Dr. Anderson, the forensic pathologist?
Dr. Atkinson?
Atkinson.
Mm-hmm.
So, when did he call you?
It was days later.
Days later?
A day or two later.
Okay. And in that conversation, and I don't want to get too much into it, he's going to testify on his own. Did he just say, "Hey, I'm going to label this as a homicide"?
No, we talked about what he had found.
Okay, just his findings.
Correct.
To your knowledge, had he made any conclusions at that point in time?
No, he had not.
Okay. Because as the coroner now, then deputy coroner, when you have a case like this and the medical examiner is going to issue his findings, right?
Yes.
Cause and manner of death.
Yes.
Right? Is that finding in that autopsy, is it sent to you so you're notified of it?
Yes.
Okay. So you would have received it in this case too, right?
Correct.
And you received that sometime around the beginning, or I'm sorry, around June 12th of 2019.
Yes.
Okay. So almost an entire year later, right?
I would have to go back and look.
Okay. How common is it? How long does it normally take? And granted, it's gonna change depending on the case. How often does it take you to get an autopsy back?
It takes several months, sometimes up to 6 months.
Sometimes. So this one's a little unusual, right?
Correct.
That it took. I'm saying you don't know, but I'm saying it took around 11, almost 12 months. That would be unusual.
Not necessarily.
Well, you just said it generally takes 6 months.
Generally.
Generally.
There are
So-
some cases where we have to send off DNA, and it can take up to a year or two.
Okay. Do you know in this case if they sent off any DNA?
I do not know at this time.
Okay, that's fine. But the normal amount of time, according to your testimony, would be about 6 months.
Correct.
Now, you also stated on direct that you waited several months to issue the death certificate. Now, was that after you received the autopsy report?
I would have to go back and look at the death certificate to see when it was issued.
Okay.
Because generally, we get a report from GBI, and that can take months. And then I can issue a death certificate.
Oh, correct. What I'm asking is let's just say it took 11 months to get back the autopsy report.
Yes.
After you received that report, do you normally immediately do the death certificate?
I do.
Okay, but in this case, you said you waited several months.
There was an issue between the funeral home and the family. They had picked one funeral home, and then they had changed their mind. And the Roswell Funeral Home had issued it in a system called Gavers, which we do computerized, and they couldn't take it out, so I couldn't do it.
Okay, so it didn't have anything to do with the case that it took you so long to issue the death certificate. It was something outside of your hands.
Correct.
Okay, that's what I'm trying to get at the bottom to. Also, going back to the smell that you were talking about, you stated that was on the 4th of July?
Yes.
Let's talk about, you were talking about you saw track marks in the backyard?
Yes.
Well, were those back here, because that's the way you went in, or the top of, what is this, S. Ferris 11, back here?
Yes, as you're facing the house, if you go around the left side, then it's the pile, the burned, smoldering pile is right here, and the Kubota was like towards the front of it.
Towards the front of it. Okay, so
In front of the back of the house.
Say that again.
The back of the house is right here, and the Kubota was right here, and the pile is right on the other side.
Do you know who the lead detective was, crime scene technician on this case?
Crime scene was Detective Shaw, I believe.
So obviously you would have pointed that out to Detective Shaw, right? Or one of the other technicians?
I was talking to Captain Hands at the time we were talking.
Captain Hands at the time? Okay. Who was he? What was he doing?
He was the captain for CID on scene.
Okay. You also talked about with Ms. Frankish about that you could move, or you have moved somebody approximately 250 pounds by yourself?
Correct.
But that is using straps and tarps and things such as that?
Correct.
Okay. So basically using other implementations?
Correct.
Okay. I'm assuming if you have you ever had to drag somebody through the woods like that? Using straps or tarps or anything?
We have had to retrieve somebody.
Yeah. And I was
From the
assuming
woods
you could see your drag marks where you were pulling the remains?
Well, we put him on a gator.
Oh, okay.
That's what I was thinking.
All right. So you could probably see tire tracks then, right?
Correct.
Okay. Yeah, that's all I got, Judge.
I have no redirect, Judge.
All right, you step down, Ms. Sims.
Thank you. Thank you.
I want to chat about generally the finances in your family and your father, his knowledge and control of that. What was your perspective, or what did you know about your father's oversight of the family's finances? Did he have a routine? Would he chat with everybody about what they were spending?
I just know, I mean, he was such a, he always had his habits. So growing up, it was Sundays. He would go down to the computer and he would check the bank account. And usually it's like Sunday's the day that you don't upset him because he's about to get upset about the checking account. I mean, if ever there was any arguing between my parents, it was usually with how much money my mom had spent that week during just shopping and stuff. I don't know if he continued to do that after we had all essentially moved out, but he looked at it. I wouldn't say he would do it every day. He's a very busy guy, but he looked at it on a weekly basis.
I want to talk about your house in Tennessee that you and your husband purchased. Tell the jury a little bit about that and how your dad had to get involved.
Sure. We bought that house in 2016. So anyway, my husband and I, we were getting married. We decided that we were ready to buy a house. So we started looking at a house, and we found one in Thompson Station, Tennessee, and we were going to purchase it. All was good until we got to the underwriting portion of the mortgage application, and we discovered that my husband was not going to be able to be on the mortgage because he had a previous judgment against him that would keep him from being eligible. So I pretty much went into panic mode. As a first-time home buyer, I was like, oh my gosh, like we've already invested all this money. We have not only done the down payment, but we've upgraded and things in the house. It was a new build. So we had put a lot of money into it, and so I was very nervous about losing it. So, I mean, my husband reached out to me, and he was very upset that he wasn't going to be able to be on the mortgage, and I was like, let me just reach out to my dad. He will help us. And so I did. I reached out to my dad, and I said, this is a situation, like, is there any way that you're willing to be a co-signer? Because, my husband and I both worked full-time. He had the higher salary of the two of us, so myself alone on the mortgage would not have been enough. So I did reach out to my dad for help, and he said, I know what it's like starting out, and yes, I will absolutely help you. So, I'll be honest with you, we did try to keep it kind of a secret from my mom, just because we knew she would be upset about it. But then in the state of Tennessee, whenever you go to purchase a house and you're married, your spouse has to give you permission to do that. So we had to tell her. She was very angry that he was helping me. Very angry. But basically, she said the only reason that she would agree to it or allow him to do it is if she were put on the deed to my house.
Okay. What does that mean for those of us that
She
don't
would have
really know the
ownership.
process?
She would have ownership of my house. And that was upsetting, but I was in a really bad situation, and I knew I really had no other option. And I was like, it's okay. That's what I told my husband. I was like, it's okay. We'll do this right now, and we will refinance once, like, a year. We'll let a year go by. We'll let this, judgment fall off, or like settle on your record. We will refinance, and we'll get it under our name, and it'll be fine. But it made me very uncomfortable to have her. My dad was a very reasonable person. He's very logical. So, like, I knew he would never give me a hard time. I knew she would give me a hard time. And that made me really uncomfortable. Basically,
Resuming on day 3 after the lunch recess. Anything to take up before we bring the jurors out?
Nothing from the Commonwealth? We're good.
Okay, Chair, please bring out the jurors.
Please rise for the jury. Jurors in the box.
All right, thank you so much. You all may have to take your seats. Jurors in the box. And jurors, are there any issues to report to the court? Okay, nothing has been said. All right, next witness, Mr. Jenkins.
Commonwealth calls Mark Garcia.
Good afternoon. Come stand in front of Madam Clerk, please. Raise your right hand.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay, sir, take a witness stand, please. Watch your step. Okay, you can adjust the microphone and please answer questions the attorneys may have.
Good afternoon, sir. Would you please tell us your name?
Mark Lincoln Garcia Sr.
All right, so I know that I mentioned this to you earlier, but just as a reminder, we're not saying the names of any children at all today. You're welcome to use initials or refer to them, like my son, for example, but no names. I want to, do you have a son?
Yes.
And what is his initials?
MJ.
All right. Did MJ attend Rich Neck Elementary School?
Yes.
Was MJ in attendance at Rich Neck on January 6, 2023?
Yes.
How old was he then?
7.
On January 6 of 2023, did you go to Rich Neck Elementary School? Well, first of all, let me ask you this question. Did you take MJ to school?
Yes.
So was that in your car? Did you personally drop him off?
Yes, I drop him off every day.
Okay. And on that day, did you go back to Rich Neck Elementary School sooner than you normally would?
Yes.
When you arrived there, I want you to describe what you saw occurring without telling me what anyone was saying.
Okay. Well, getting there was a task because once you get to Jefferson, going down Rich Neck, it was kind of like cordoned off by the cops and a lot of people trying to go there. So we had to go to the adjacent road, which is Monroe. And we had to come down Monroe, and when we got to Monroe, we had to stop because there was a lot of cars. So I parked my car in somebody's house, so they said we could park there, and I got out my car, and I parked my car, and I went down the road, and there's a church that's on the right-hand side, and that's where everything was cordoned off by the cops, and that's where all of the confusion was going on because nobody knew what was going on.
So did you go to that church area where people were gathering?
In the middle of the street.
Okay. And did you immediately see MJ there?
No.
Okay. From the time you arrive, and I know I'm asking you to estimate, but can you give us an estimate? Are you able to give us an estimate of how long it was from the time you arrived at Rich Neck to the time you saw your son?
Response.
This is the connection, Judge, that we have been talking about in this case between the shooting and the ensuing trauma to the children, and that came from a delayed reunification, and that came from, as we will hear in a moment, that came from the continued chaos leading to these children in a panic and a state of trauma.
Your Honor, I'm going to continue to object. Even his response to this is a narrative testimony in front of the jury.
What's the nexus to why we're here? And I guess I'm missing that. If you can expand on that, if not, it's sustained.
The nexus for why we're here. Let me look at the statute and read from the statute. 18.2-371.1. Any person responsible for the care of a child under 18 whose willful act or omission in that care was so gross, wanton, and culpable to show a reckless disregard for human life is guilty of a Class 6 felony. As to how
A delayed reunification.
the shooting,
Yes.
Judge, the shooting occurred, and everything that has happened to these children is a follow-on from the shooting that establishes it is gross, wanton, and culpable behavior of Dr. Parker. It was the willful omission that caused these children to be separated from their parents in a state of chaos.
I sustain the objection. Next question, please.
Mr. Garcia, after you were reunited with your son, describe his demeanor, how he looked to you.
Objection again to relevance, Your Honor.
He can describe that. I will allow it. Overruled. You may answer the question, sir. Do you need him to repeat it?
Okay. My son looked confused. He was very scared and very shocked that all of this took place in his school, in which he loved.
All right. And are there any ways that you've noticed as a parent that your son is different was different after the shooting versus before the shooting?
Yes.
Describe what you noticed.
Objection
And objection to relevance.
Okay, I didn't hear, okay, leading and relevance. He can describe what he observed when he sees his son. Go ahead. Overruled.
So, my son, he's in therapy. He has to go to therapy now. He's still scared of the dark areas in which they have to be pushed in their safe room. He's not comfortable in certain situations like he used to be, like being talkative and things of that nature.
Objection, Your Honor. If I can just sub questions out of this.
Yes, sir.
Even regarding the statute, the things the Commonwealth has to prove, this is, the things that he's testifying to is not a material fact that has to be proven or established to prove that Dr. Parker is guilty of this crime. He's testifying as to things that occurred afterwards, but nothing regarding Dr. Parker's conduct or lack of conduct. So it's not relevant.
Response?
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is as far as I'm going with this. But the fact that the child is different after than before is relevant to whether the choices Dr. Parker made were gross, or the omissions were gross, wanton, and culpable, because this is the after effect to the children.
It can end here, but again, I'll let you finish, Mr. Rogers. But as to where we are now, I'm going to overrule defense objection. You can ask that one question. The gentleman may answer that question, but then we're going to stop. Yes, Mr. Rogers.
Just for the record. Your Honor, I might agree with Mr. Jenkins if the Commonwealth had to prove some type of serious injury, but that's not what is charged. It's felony abuse and neglect, but it's not based on any injury. It's based on my conduct and not any impact on these children.
Anything additional?
Not from me, Judge.
Okay. Do you need the attorney to repeat his question?
Yes, please.
Okay. How was your child different after the shooting versus before?
Yes.
Describe how he was different after.
Would you like me to describe before?
If
You
you
have to answer the question that he asked.
Okay.
Yeah.
So after, again, my son, he doesn't like sleeping in the dark because of being in that safe room for however long they were in that safe room, being confined to an area, having, I don't know how much light it was, but he's scared of the dark, having added more light and going to therapy.
Okay. And were any of those things present prior to the shooting?
No.
All right, thank you. I don't have any further questions for you.
afternoon, Mr. Garcia. I just have a few questions. Are you familiar with any relationship that your son had with Dr. Parker?
No.
Okay. Your son was a second grade student at Rich Neck, correct?
Correct.
So he was not in Ms. Leonard's classroom, correct?
No.
Okay. You mentioned something about a safe room. Isn't it true that your son was in the gym?
No.
Your son was not in the gym when you
No.
picked him up?
No.
Okay. Where was he?
I don't know.
Oh, you don't know?
No, we were told by the police.
Oh, well, I'm not asking you to tell me what somebody told you.
Okay.
So you don't know?
No.
Okay. You filed a civil lawsuit arising from the events on January 6, 2023, correct?
Correct.
Okay. And it's filed here in this courthouse, correct?
Not sure.
You're not sure?
No, I got it. You have to talk to my attorney on that.
I'm sorry?
You have to talk to my attorney on that.
Okay. You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not going to talk about that on camera because it's streaming.
Judge, I am going to make a limited objection here in that any civil suits relate to the children, and I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording while he discusses his child, and I support that request and ask the court to do that.
Response?
Well, Your Honor, he just asked a series of questions about the child on camera. I'm asking about a civil case, asking him whether he filed a civil case. It has nothing to do with the child himself.
So the objection is overruled. Cross-examination, the questioner is allowed to examine the witness's interest in a case. And for the witness, we are not using names, we are using initials as we previously did. So that is the protection to minors in this case. All right, you may proceed, Mr. T.
Mr. Garcia, you are seeking money damages from Dr. Ebony Parker in that civil case, correct?
Yes.
And a criminal conviction of Dr. Parker would assist in your civil case against her, wouldn't it?
I believe so.
Okay. So you have a financial interest in the outcome of this criminal trial?
Financial. What do you mean?
Well, you just stated that you believe that a criminal conviction of Dr. Parker would assist you in your civil case where you're suing for money, correct?
Yes.
Okay. So you would agree you have a financial interest in the outcome of the criminal trial, correct?
Possibly, yes.
Okay. When did the school first contact you about the shooting?
January 16th.
16th?
Yes.
Okay. So 10 days after the shooting occurred? Okay. And how did you get that notification?
I was called by the city, the Newport News Public Schools, I forgot the name of the downtown director of people, but I know her name is, I know her name, but she called me at 6 o'clock on the 16th.
Okay. And do you consider that failure to notify you for 10 days a failure?
Absolutely.
And do you believe that failure is on the part of Newport News Public Schools?
I believe it's on the part of the school system as well as Newport News Public Schools.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. You've indicated on cross-examination that your son, MJ, was not in Miss Werner's classroom. What was his homeroom?
His homeroom was Mrs. McArthur's class.
And Did he have occasion to interact with other students from other classes?
They were in the same hallway.
Now, in the immediate aftermath of this, when you picked him up, did he tell you anything about contact he had had with another student?
Objection, relevance, and hearsay.
Okay, and I was going to ask you, are you asking me to give the statement or just to?
I am going to attempt to establish possibly an excited utterance.
Okay, all right, so there's an objection.
Yes.
What's your response?
What is the legal basis for the objection? I missed it.
If you can repeat, Mr. T.
Relevance and hearsay.
Okay, so it would be hearsay unless the court finds that the excited utterance exception applies. I'll need to lay a foundation for that. Well,
So if you could lay a foundation and to the witness, sir, when we ask you to pause, and we can make sure that the evidence is appropriate under the rules of evidence.
Yes, ma'am.
You may proceed.
in the immediate aftermath of the event, right when you see your son, does your son speak to you about the event?
Yes.
Does your son tell you about a child he interacted with that day?
Yes.
Okay. And do you know who, just a yes or no question, do you know who that child is?
No.
Okay. When your son is telling you this, can you describe for us, without saying what he said, can you describe his demeanor, how he appeared and how he was acting, and how he sounded?
He was scared, shaky, and nervous.
Okay. Did he relate to you something that had just happened earlier that day?
Correct.
Judge, I think that is sufficient foundation as to hearsay under the excited utterance.
Yes, sir. Anything from the defense?
Yes, Your Honor. He has, Mr. Cumberland has not established any foundation regarding excited utterances. We don't know how long before, and if we're talking about the shooting that had occurred at 2 p.m. and the father didn't pick up his child until sometime later in the afternoon, presumably hours later, then I don't see how it qualifies as an excited utterance.
May I respond to that, Judge?
Yes, sir.
The excited utterance exception is extended when the declarant is a child, because courts have recognized in Virginia the nature of being a child and brain development means that the heightened experience of an emergency extends quite some time. There are cases that I will have to look up if the court would like that involve many hours long when the child is young. The younger the child and the more traumatized they are acting, the longer the extension of the excited utterance is.
I am going to sustain the objection. The legal basis would be as such. Reading Rule 2:803, excited utterance. So an excited utterance is defined as a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with first-hand knowledge at the time under circumstances negating deliberation. Again, my pauses are to show the clauses and breakup and how to decipher that. It has not been established that the declarant, which would be the witness's son, had first-hand knowledge at a time, as he was not in the affected classrooms, and there's been no evidence other than that being a student at school since it happened, as to how he would have gained first-hand knowledge through an appropriate way. So I'm going to sustain the objection.
I'm going to request to voir dire the witness so that I can establish exactly that.
Okay, and you're asking to do so out of the presence of the jury?
Yes, Your Honor.
All right. Ladies and gentlemen, if you kindly retire to the jury room and we'll bring it out as soon as we can. Thank you.
Please rise to the jury.
parties may have a seat. And to the witness, you're still under oath. We're going to have some additional questions for you. But one more will wait for the door to close. You may proceed.
In that moment where you were just describing his demeanor, tell us what MJ told you.
That my son sits on the last seat because they don't have any doors in their classroom. So his seat, he could hear the pop. When he heard the pop, the teacher, they heard over the walkie-talkie that someone got shot. And they got everybody scrambled into the outside of their classroom, which was in the direct line of supposedly their safe zone, which is outside of their classrooms.
Okay, let me ask you this question. Did MJ say all of that to you in that moment?
Yes.
Okay. And so, if I understand your testimony correctly, is it that he heard the gunshot and he was in a classroom that had no door?
Yes.
Okay.
He heard a pop, I believe.
A pop.
Yes.
Testimony was.
And then he had to evacuate with the school, basically.
He had to evacuate his classroom in the danger zone.
Okay.
Say that you're saying in or and the danger zone?
In the danger zone, because his class has no door, so the zone of where they have to go out is outside of their classroom in that same hallway.
Okay, and he used the word danger zone.
My son?
Yes.
No.
Okay, I think he's asking you what did the child say? I mean the verbatim statement.
He was in his the safe room. He went to the safe room.
Okay.
Okay, and Mr. Rogers, you were saying something, you want to say something?
I was going to address his characterization of danger zone. I think the court has done that.
I'll continue with your vote.
Judge, I'm not going to seek to admit the statement. We need to bring the jury back up.
Okay.
Thank you,
Bring the jurors back in.
Mr. Garcia.
And I know you all just stood. You can keep your seats this time. And I'll explain to them. I gave you a break. It was just a few minutes ago. You can bring them out, but everybody doesn't have to stand. You all are welcome to have a seat once everyone comes in.
14 jurors and five.
Thank you very much. Okay, the jurors have a seat. And normally they stand. I told them that they just stood. They didn't have to. So it's no disrespect to you all. It was just my command. So you may finish with your questions if you have anyone.
Yes, Your Honor. Mr. Garcia, had you personally ever been inside Witch Neck Elementary School?
Yes.
Had you personally ever gone to your son's classroom?
Yes.
And did your son's classroom have a door?
No.
All right, thank you. I don't have anything further.
Cross-examination?
I think we're fine.
Defense has no questions.
No question.
Okay, all right. And the status for this witness?
I would ask that he be released unless there's an objection to it.
He can be released, Your Honor.
Okay, so sir, what that means is you're released from your obligation as a witness. You may stay in the courtroom, you may leave and go about your business, and thank you, sir.
Thank you so much.
And next witness,
Commonwealth will call Susan White.
Susan White.
Susan White.
Thank you.
Raise your right hand, ma'am. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? I do. All right, you just have to get there.
Your Honor, if I may.
Yes, sir?
I know the court has already ruled on Mrs. White's.
Okay, come on, hold on one second. Come on in the witness stand and watch your step. Yes, you can move the chair and microphone. Yes, Mr.
The court's already ruled on Mrs. White's ability to be able to testify today. I'm renewing my objection to any testimony that she may give regarding how it's not relevant to what happened on January 6th regarding my client's conduct in the actual mission that occurred on that day. She can't testify to that because she didn't observe it. So I don't believe that she has anything of relevance to offer the fact finder to be able to decide if my client's conduct is appropriate or not.
So noted, thank you. You may proceed, Mr. Chairman.
Good afternoon. Tell us your name.
Susan White.
Ms. White, how are you employed?
Right now I'm retired.
And on January 6th of 2023, how are you employed?
I was retired by then too.
Okay. And were you at Rich Neck Elementary School?
Yes, I was.
Why?
I was there for 34 years.
Okay.
And my last year was the year before
Right.
that happened.
And so I want to take you back to the year before that, which was that your final year before retirement?
It was.
Okay.
No, I'm sorry. I don't believe her answer was responsive to the question. There may have been a misunderstanding as to what was asked. So it definitely wasn't.
Okay, you can clear that up on cross-examination. You may proceed, Mr. Jenkins.
So during the course of your last year of teaching at Rich Neck, did you know a student who we're referring to as JT?
Yes, I did.
Okay, and as a reminder, we're not speaking the names of any students at all, only using initials. Whose class was JT in?
My class.
And what grade was that?
Kindergarten.
Okay. During the course of your time with JT, was there ever a discipline incident that you did report directly to Dr. Parker?
Yes.
I want you to start at the beginning of that incident that you eventually reported. So what was going on that day that began that?
He had gone up. This was during post-COVID, so we had to be careful with distances and with masks. And he'd gone up to the front of another child's desk with his chair and put his face over about 3 inches from the other child's face. And so I had to think, what am I going to do about this? Because just telling him no, or you need to get back to your seat or whatever, those weren't working with him. So I slid the chair slowly so that if he wanted to get up, he could get up. And if he didn't want to, he could stay seated. I was going to bring it to his desk. But then he pulled the legs away and dropped them. And so I brought it up a little bit further just so I could be right in front of the class. And I sat there and I kept on teaching.
Okay.
So I was still talking with the students.
Let me pause you for a moment so we can kind of visualize the scene. So when he is in the face of another student, how is he? Is he sitting, standing, or doing something else?
He's sitting, leaning in toward him, staring him in the eyes.
Okay. And you testified that you pulled him away. Could you describe how you did that?
I slid the chair I was holding the back of the chair and I slid it back. We had no carpets at that time because of COVID. So it was easy enough to do.
Yeah.
And so he hopped off and grabbed the front legs of the chair and pulled them forward. But I was able not to fall, but to still hold on. So I could get it a couple feet further and I just sat on it.
So when he pulled the legs, had he stood up out of the chair?
Yeah.
Okay.
Oh, yeah.
So what happens after that point?
I was sitting in the chair and I was talking to the class, and not about behavior, about the instruction we were doing. And he walked up behind me and put
both of his arms in front of my throat and locked them together and pulled back and down hard. I couldn't breathe. And he didn't let up on it. The only way I got out of that situation was the assistant, the teacher's assistant that I shared with another teacher, happened to be in there at the time. She was in the back of the room. So she came up and pulled him off with me and took him out of the room. But until she pulled his arms off, I couldn't breathe.
What, if anything, happened with JT immediately after that? Does he run out in your room?
No, I wouldn't have had it. I would have left if he did. No, Mrs. Parker, my assistant, took him out of the room. But then, sometime later in the day, and it got very blurry after that for me, so I can't tell you how long. One of our counselors and our security officer came and brought him back to my room.
So when you say, hold on, when you say brought him back, do you mean JT?
Yes.
Okay.
Yes.
So when you
each had him, I'm sorry.
When you see him come back to your room with the counselor and school security guard, what happens?
They each had him by one hand, and they were trying to get him to move into the room. And he was yelling, "No, no, I don't want to go back in the classroom." And I looked at them, and I had his back to the doorway so I could talk to them without everyone in the classroom hearing. And I said, well, he's right. He does not belong back in the classroom. What he did was severe enough for me to contact the police and to press charges. And the security officer agreed with me.
Okay, so what happens with JT next?
Well, they told me they were bringing him back to me because no administrator was available to handle the situation.
Okay.
So I said that if he was going to stay in there, I was going to need to leave the room.
Did you in fact leave the room?
I did, but not because of that. I believe they took him back out again, but it's very fuzzy.
Okay.
What I know is by that point I was so shaky that Mrs. Carter, my assistant, said, go ahead and take a break. And I took my laptop and went to the lounge and got the incident referral form because I wasn't going to leave school without reporting that.
Okay, so hold on just a minute. You've mentioned an incident referral form. Can you just kind of explain to the jury what that is?
That's if you think the discipline problem is dangerous enough or bad enough that you need to refer them officially, formally, to the administrators.
And when you say the administrators, what titles do you mean?
Assistant principal and principal.
Okay. And who was the assistant principal at Rich Neck Elementary School at the time that this happened?
Dr. Parker.
And is Dr. Parker in the courtroom right now?
Yes.
Could you just point her out, please?
She's right there.
Okay. Will the record reflect that she's indicated defendant?
I was not, can you point her out again? I didn't see your hand. Okay, so noted.
Thank you, Jim. So you've told us that you got an incident referral form, okay? And what did you do with it?
I filled it out and I typed up a whole description of everything that had happened that day because I had had some positive moments with him earlier, so I wanted those included too. So typed up the day and then I attached it to the referral form as the attachment and the explanation of the behavior. And then I went to the office and I saw that Dr. Goodman, the principal at the time, and Dr. Parker, they were in her office at the time.
And did you go into the office?
I went into the office. I told them everything that had happened.
Let me ask you this question. Did you have the incident referral form with you?
I had it in my hand.
Do you know who you handed it to or what you did with it?
I handed it to Dr. Goodman after I explained everything on it to both of them.
I understand. So after you explained everything that was on it, did, if you remember, did Dr. Parker or Principal Goodman react to that in any way? And if so, how?
Dr. Goodman did. When I was talking about the fact that if an attack is occurring it should never be that no administrator is available to help with it unless there's a worse attack going somewhere at the same time.
Okay, did Dr. Parker say anything or
No,
have it?
she was making eye contact. She was looking at me. She didn't say anything.
Okay.
Dr. Goodman said, sort of under his breath, prioritized. And I thought, well, yeah, that's what I wanted him to get from that. And then he told me to go to the nurse and have my neck checked out afterwards.
Okay. That year, did JT ultimately return to your classroom or not?
He did.
Okay.
He returned the very next day. He walked in with his breakfast.
Okay.
And I immediately went to the teacher across from me and said, I need to go to the office so that she would watch both of the classes. And she saw who I had with me, and so she understood. And I just told him, he had his breakfast with him. I said, just bring it and come with me. And so we went to the office, and I had him sit down in the waiting area for parents there. And I went into Dr. Parker's office, and I knew at that time that my assistant had to stay in a first grade class all day because the sub hadn't showed up. So I would not have another adult in the room. So what I told her is, I cannot be the only adult in the classroom if he's in that room. And so either he needs to be somewhere else, or I'm going to have to take a sick day and go home.
And was he relocated or what happened?
He must have been, because I went directly back to the classroom and continued teaching for the day. I didn't see him the rest of the day.
Okay. At some point later in the year, does he come back to your classroom?
No.
Okay. If there were, and if you remember, any other discipline incidents you saw yourself and you reported to Dr. Parker yourself, are there any such incidents?
With him?
With JT, that's right.
No, I don't believe so.
Thank you so much. I don't have any further questions for you. Please answer any questions of the defense counsel.
You have a moment?
I'm sorry.
Okay. Are you all right?
Yeah, I'm okay. I thought he was asking me. I'm
Oh, no,
sorry.
it's a moment to confer.
Hello, Ms. White. You just testified that you reported JT's behavior or his presence in your classroom to Dr. Parker directly when he came back the next day, correct? Mm-hmm. Okay. And then when you told her that, after that, he never appeared in your classroom again, correct?
Right. And I heard, but...
No, you don't tell me what you heard.
Okay.
So when you told her that action was taken and justice was JT was removed from your classroom?
He went to another school.
Okay. All right. Regarding the incident referral that you mentioned, do you know whether Newport News Public Schools retained a copy of it?
I was told they didn't.
Okay. And did you have to then supply it to someone else, your own copy that you maintained?
Yes.
No further questions.
Can you read it? Direct.
Yes, Your Honor. Ms. White, I want to just direct your attention to the incident referral form. You've indicated there was a form. Was that the only piece of paper you submitted?
I submitted the referral form with the attached description of the day.
Okay.
So that I could get the full explanation of what happened, because this little place is not going to be enough.
Understood. And the a description of the day that you attached to the referral form, was it typewritten, handwritten, or something else?
Typewritten.
All right. If I showed it to you, would you recognize it?
Definitely.
May I approach the witness, Your Honor?
You may.
May I see the exhibit?
You may.
Sure. May I approach the witness, Your Honor?
You may.
What is
Yeah.
it? What is it that I paid you?
You handed me the detailed description that I attached to the incident referral form. And
Okay, and is what you're looking at now a true and accurate copy of the incident report as you wrote it?
yes,
Has anything been redacted from it?
well, yeah, but I did that myself for some that I gave to other people.
What was redacted? Is it a category? I don't know, I sort of words. Is it names?
Names.
Hold on 1 second, ma'am. What? Yes, sir.
Before she even answers that, objection, that document is hearsay, it's an out-of-court statement, it's written, being offered for its truth of what happened on that day. She's testified as to what occurred. She's testified that she produced this incident report, but as far as the contents of that incident report, I'm objecting to it as hearsay.
The objection is premature. I haven't offered it as evidence yet.
Okay. Agreed, premature, not yet right. You may proceed.
The redactions that appear are the redactions that you did.
The names, yes. I don't know what I had at the top.
Okay. Are you sure that that is the incident referral that you submitted attached to the form?
It looks like it.
Okay, it either is or it isn't. Take your time to read it.
Yeah. I was going to say I write a lot, but yeah.
So is it the incident referral?
Mm-hmm.
Is that yes?
Yes, it's the
Okay.
attachment that I attached to.
Thank you. Judge, I am moving that now into evidence as Commonwealth 6 as a past recollection recorded for one thing, and also as a prior consistent statement, because the defense was alleging that or suggesting that it didn't exist, essentially, in cross-exam.
Your Honor, there was no such insinuation that it didn't exist. So that's number one. It's still hearsay, is duplicative of her testimony, and all the previous objections that Mr. Rogers lodged. And it goes beyond, I'm sorry, Your Honor, it goes beyond my redirect as well. I mean, my cross-examination.
And also, how is this not bolstering? How is this permissible bolstering? She testified to what she recalled happened, I think it was a year before.
Yes.
So, I'm talking to the attorney.
I'm sorry.
She testified to what she believed happened to her a year before. Why are we allowing in her written statement, her redacted written statement about that?
Because defense counsel asked whether she gave it to the schools and whether it still exists. And I'm establishing that it does.
Okay, so I guess you're interpreting that as an attempt to impeach, and so you're trying to rehabilitate?
If the objection is hearsay, there's an exception to that. If we want to talk about why it's relevant at this stage, yes, we can go to the relevance rules and find that a prior consistent statement does become relevant when on cross-examination, or does become admissible when on cross-examination the witness has been challenged as to having a memory or forgetting something. I could find a rule.
And again, I understand that's where the impeachment comes in, but that's the missing link for me. So, sustained, it does not come in, and you may approach to retrieve the document.
Thank you, Judge. So, thank you. I don't have any further questions for you.
Anything further? Okay, and the status for this witness? May she be excused?
I'd ask that she be released unless I'd ask to be released.
Okay, and no objection from defense. Okay, so that means thank you for your testimony today. You are released as a witness. You don't have to go back to that room. You do not have to stay in the courthouse. You are welcome to remain in the courtroom if you'd like. Okay, and watch your step down. Thank you very much. Next witness.
Commonwealth calls for Alonzo Rawls.
Raise your right hand, sir. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Please take the witness stand, sir. Watch your step, and you can adjust the chair and microphone as you need. You may proceed.
Good afternoon. Would you please tell us your name?
I'm Alonzo Rawls.
Mr. Wells, just a quick reminder that we're not using the names of any children today in court. We'll use initials in place of that. Mr. Wells, in January of 2023, how were you employed?
I was a school counselor
Where?
at New Plymouth Public School at Richmond Elementary.
All right. And how long had you, as of the January 2022 or 2023, I'm sorry, how long had you been at Richnet?
It probably would have been, between that time, it would have been like a year and a half.
Okay.
Not quite 2 years.
And during the course of your time at Richnet, did you come to know a student who we'll refer to as JT?
Yes.
And in the course of your duties, did you receive an assignment related to JT?
Yes. In his second year at Richneck, I was assigned to kind of be like his one-to-one within a set schedule.
How did that assignment come about, if you know?
I don't recall in its entirety. I do believe that originally, because he was having some issues, they were trying to put a plan in place to help him to adjust him to the school and, be more productive. So I believe the administration came with a plan up and they administration need to help him out within that plan.
Tell us how, if you could, just describe for the jury how the one-on-one assignment worked. What did you do?
Well, in the morning when he got off the bus or was dropped off, I would proceed to have like a morning session with him, kind of set goals and plans for him in the morning. He would then go to one of the, I believe it was one of the SPED teachers to kind of reiterate those plans. After that, he was working with Mrs. Kovac on some things like reading assignments. She was a reading specialist at that time. And then after her time was up, I would come back, retrieve him, and I would take him to the classroom. I would be with him in the classroom.
Okay. And Did you ever speak to Dr. Ebony Parker regarding this assignment with JT?
From my recollection, I don't recall. I just remember this is when they were requesting that.
Okay. Do you know of any behavior issues that JT exhibited?
Yeah, on his first year there, he exhibited a variety of different behavioral issues where he was out of the classroom or taken out of the classroom for whatever case may be, but it varied from time to time.
Okay. Mr. Wells, do you know what an SST is?
Yes.
Okay, what is that? Can you tell us?
Student support team. It was basically a process or a program to put in place to help to assist them in trying to, once again, be more productive within the school system.
And did the SST plan involve regular meetings?
Yes.
Did JT have an SST plan?
They were in the process of moving forward with SST because I believe they were trying to transition that SST into more like an IEP, which is like a more specialized support system for students, and it's called the SPED system.
Okay. And who all was involved in the SST process for JT?
I was currently at the time on the Newport News Public Schools of policies, counselors were one of the main people that ran the SST process. Administration would be involved when available and things of that nature, but it was more so put on the responsibility of the counselors.
Okay.
To coordinate the SST meetings.
And so at those SST meetings, who would typically attend JT's SST meetings?
It would be either the principal, the AP, myself, or another counselor, a parent, and if they had any advocates, anyone else that would be willing to be part of the meeting. That's how kind of group of people would be.
Were parents and guardians of children invited to attend those as well?
Yes, of course, yes.
You've mentioned principal and AP. What's AP?
Oh, assistant principal.
Thank you. And as of JT's SST, who was the principal at the time?
During the time, the principal,
I'm sorry, I put you on the spot.
I can't remember.
Okay, do you remember who the assistant principal was at that time?
Dr. Parker was assistant principal during the SST process in that second year, yes.
Okay. Did Dr. Parker sometimes attend the SST meetings, if you know?
I believe she may have attended somebody else.
Okay. Did there come a time when you decided you no longer wanted to, or maybe that you no longer thought it was useful to have that one-on-one assignment?
Yes, because...
Hold on just a moment.
Okay, what happened? I heard something. Object leading. Okay, response.
I'll rephrase the question.
Thank you.
Did you ever decide that you did not want to continue the one-on-one relationship with JT?
As a school counsel,
Okay, same objection? Yes, response?
I asked, did you ever decide that you didn't want to continue the one-on-one relationship with JT? He's already established the foundation that he had the one-on-one assignment. And did you decide, is a question he can answer yes or no. He did decide or he didn't. I'm not suggesting which of those answers is the right one, so it's not leading.
Okay, I think the leading part is to just continue the relationship with JT. So I think the proper phrasing would be, did you decide whether or not to continue or discontinue a relationship with JT? So if you could ask that, or do you want me to just...
Go ahead, Judge, if you would like to ask the question.
Did you get the question?
Yes.
Okay, can you answer? Thank you, sir.
it wasn't really a decision of sorts. It was a request. As a school counselor at that time, I had many students that I had to serve, and and I felt like it took away my opportunity to service a lot of the other students within the building. So I had a request that if I could be relieved of that duty, so I could also service the other students. Besides, I could still assist. I heard it needed to be done with JT, but I also wanted to be able to service the other students within the building as well.
Thank you. During the time that you were working one-on-one with JT, did you experience behavior issues or witness behavior issues?
Can you repeat the question?
During the time you were working with JT, did you experience or witness behavior issues?
When we were more one-to-one, it tapered off more. He still had concerns here and there, but relationship we had, me being his one-to-one, that I would be there to help to correct or redirect a lot of his behaviors.
And what were the behaviors that you observed of JT at any point that year?
Non-compliant, defiant behavior, refusal to do work, just acting out of sorts where he wasn't following directions, things of that nature.
Would those issues ever be discussed at the SST meetings?
At times, yes.
Okay. I'd like to take you to January 6th of 2023. You remember that day?
Yes.
What is the first moment that you realize something might be up with JT?
Objection, leading, assumes facts not in evidence.
I'll rephrase.
Yes, sir.
On that day, did you ever notice anything unusual about JT?
On that day, I didn't even really witness him that day until later, in that evening of the afternoon of that day.
Okay. Did you eventually become aware of a crisis that occurred that day?
It was brought to my attention that after dealing with another student, that something had took place at recess where JT apparently told another student something that
Object here, sir. Your Honor.
So I understand it's hearsay. Let me walk through that with him. During the day on that day, did you have occasion to speak with any students?
Yes.
And were there any students who shared a concern related to JT?
Yes.
Now, without telling me what the student said, did you describe the student's demeanor, how they appeared at the moment they were telling you the information?
They were very emotional, very sad.
Okay. Again, without telling us what was said, were they referring to something they had just experienced or seen?
I wouldn't say they just experienced it, but they experienced it at an earlier time where they were still holding on to whatever was stated.
Okay. And with that information, without telling me what was said, with that information, where did you go?
With that information, where I went is I went to Dr. Parker to address the allegations that I heard.
Okay. Did you ask Dr. Parker to take any action?
I didn't ask her to take any action. It was presented to me that some action was taken at a particular time with something else, and then I requested her if I could take some action.
Okay. And what action did you ask Dr. Parker to take?
I asked her if I could take action of trying to search or to check the person about JT.
And what did Dr. Parker say anything?
She responded by saying that at the time, because of the scheduling he had, his parent or parental guides would be coming to get him, so that we could hold off at that time.
Okay. The concern and the desire to search JT, did you share your concern without telling us what was said? Did you share your concern with anyone else?
The only person that's I shared my concern with is when I went back to speak to Mrs. Zorn after I spoke to Dr. Parker.
Okay. Mr. Wells, at the time that you asked Dr. Parker for permission to search the person of JT, did you believe that you had the authority to do that without an administrator's approval?
You know, in my previous experiences, you just can't, in my position, you just can't search a student without some type of permission.
Okay. And finally, Mr. Wells, as you sit here today, do you wish you had done differently that day? Thank you. I don't have anything further.
Good afternoon, Mr. Ross. How are you? Good. Hopefully I won't keep it too long. So, on January 6th of 2023, you were the school counselor at Rich Neck, is that correct?
That's correct.
Okay. And so, at some point, was it at the very beginning of the year, did you assume the responsibility of having the one-on-one contact with JT?
Not necessarily at the beginning of the year, no, sir.
Okay, but at some point you began one-on-one contact with JT, is that correct?
Yes, sir.
Okay, and how were your initial interactions with JT? Were they positive, or was it a challenge?
At times it could have been a challenge, but we built a rapport from the year before where it wasn't as difficult for myself.
Okay, and so over a period of time, his behaviors began to get better, is that correct?
I would say yes.
Okay, and you were part of the SST team, is that correct?
Yes.
Okay, and you function as the counselor as a part of that team?
Yes, counselor coordinator.
Okay. Would you say that you were in a pretty good position to assess how JT was doing on a given day?
I would say yes.
Okay. And would you say that you had more contact or less contact with JT than Mrs. Kovac, the reading specialist?
I would say we probably had about
About the same amount of time? Okay. And at some point, you indicated that you requested less one-on-one time with JT?
Yes.
But it didn't sound like it was because he was doing better, but it's because you wanted to be able to help more students at the time. Is that correct?
Yeah, from my standpoint, my point of view is to be able to be more accessible to students with
Okay.
Okay, if you could speak up and tap that microphone, let me see if it's on. Okay, talk into it so that the reporter can get your words down. Thank you.
I'm sorry.
So, if you repeat your answer.
Oh. Can you repeat the question?
So you got to a point where you were spending less time with JT. The motivation for that was to be able to spend more time helping, I guess, more students,
yes.
and more people than just JT. Is that correct?
Yes.
Okay.
Go ahead, and I know we're hearing that mechanical squeaking now. We think it's a chair, so just, well, you know where it came
No,
from?
it wasn't a chair. It was a voice or something like that.
Well, do you know where it's coming from, or feedback?
It seemed to be from my right.
Oh, okay. So again, there are other courtrooms and other lockups. We can't do anything about those noises. I'm sorry. Just ignore them. These things on the wall, these are sound panels. So we have as many as we can have, as you see, to absorb all the sound. So we'll just have to do our best to move forward.
Thank you, ma'am.
Okay,
I
repeat your
understand.
question, please.
So my next question is, do you, when you began to have less contact with JT based on your request, did you think that was a good move for JT? Do you think that may have been detrimental to his progress?
I can't really answer that.
Okay. But based on your position, you thought as far as resources, you needed to have contact with more students. Is that correct?
Yes.
Okay. maybe it's the, that's what it is. That's what it is.
Okay,
So I'm the source of distraction.
All right.
So after you decided to have less time with JT, did you notice any kind of degrade or in his behavior?
Not necessarily, because another plan was put in place to kind of, I won't say replace me, but to try to subside my business.
Describe that go around or that next plan.
Well, the next plan, from my understanding, was that one of the authoritative figure within his family would be able to come in to assist him and support him in his times process schedule.
Okay, and so you actually observed that next phase of the plan with JT. Okay, and did that next phase seem to cause improvement with JT's behavior?
As far as I know, once again, once I was alleviated from that, I wasn't so hands-on, but I would say it seemed like he was kind of improving, yes.
Okay, so were there less calls from a teacher or from an administrator for you to respond to JT due to bad behavior?
On my understanding, yes. It was less calls to me, yes.
Okay, all right. Now let's talk about January 6th. Did you have contact with JT on January 6th of 2023?
Later in the afternoon, yes.
Okay.
Not like direct contact, I observed him.
Okay. You said not direct contact, but you actually observed him. So as a result of hearing information, you decided to go and place your eyes on him, is that correct?
Yes.
Okay. And when you placed your eyes on him, was he in the classroom or was that on the playground? Where was he at? In the hallway?
I placed my eyes on him, he was in the classroom.
Okay. And when you placed your eyes on him, did his behavior that you observed, did it cause you concern?
No.
Okay. Did he seem like it was JT, his normal behavior? Is that
Actually, it seemed abnormal behavior. He was way calmer than he normally was.
Oh, okay. So he appeared calm. How long did you observe him?
It was a few minutes. It wasn't long.
Okay. And during that few minutes, JT was doing okay. Is that correct?
Yeah.
Okay. And is it safe to say that you may have had some concerns for JT's safety or anybody else's safety, and that's why you wanted to put your eyes on him? Is that correct?
Well, not at that time. At that time, like I said, it was abnormal for that behavior of being that calm in that setting.
Okay.
But I didn't have any concerns of him.
Okay. So you put eyes on him and you were satisfied that JT was doing well that day. Is that correct?
Yeah.
Did you have contact with him directly or indirectly after that?
No, I did not.
Okay. So you did not observe any behavior of JT on that day that made you believe that JT presented a threat of danger or harm to any of the students. Is that correct?
That's correct.
Okay. And I believe through the questioning, it seemed like there may have been an indication that there was some additional feedback that you received. Is that correct?
Yes.
Okay. Did that cause you to need to put your eyes on JT again?
The initial feedback that I received had me concerned about what was being said, and that's when I wanted to address it with Dr. Parker and things of that nature. The only other time that I saw JT, and I don't even recall really seeing him particularly, is when I went back in that classroom, and I don't remember actually seeing him at that time.
Okay. Okay. And do you remember the timing of when you went back into the classroom?
Once again, it had to be between the hours of 12:45 to 1 something.
Okay.
But I don't recall the exact time.
At any time did you feel like that you needed to step in and pull JT out of the classroom?
Only time that I felt after hearing the feedback that I would receive, and then once again I was, told to hold off on that.
Okay. Did you agree with that decision?
At the time, I felt like it was the decision that was made, and whether I agree with it or not, I was just there to be a support. When I came back to the classroom, I spoke to Ms. Zorner, I told her what was said, and I just told her that I would be there if she needed me.
Okay. When you left Ms. Warner, did you feel like you were leaving her in extreme danger, or the students in extreme danger?
No.
Okay. When you walked away from that class, you were at peace with JT's behavior, what was going on in the classroom. Is that correct?
Yeah.
Okay. Now, so when the actual incident occurred, did you immediately think that, oh no, JT has shot somebody?
No. When they went into lockdown, I thought it was a drill originally.
So you were shocked that the incident actually occurred. Is that correct?
That's correct.
Even with the earlier feedback that you received. Is that correct?
That's correct.
Okay. You did not think that you needed to take any action to prior to the incident to separate JT from the classroom. Is that correct?
That's correct.
Separate his classmates from him. Is that correct?
That's correct.
You didn't feel like you needed to call the police? Okay. All right. If you believe that there was a gun, do you understand that it was your responsibility to separate JT from the classroom?
Yeah, I mean, that would be my responsibility.
Okay.
Definitely it was.
Okay. And it would also have been your responsibility to contact authorities. Is that correct?
Correct.
Okay. You had been involved in previous incidents when JT was removed from the classroom. Isn't that correct?
Yes.
Okay. Just a couple days before that. Okay. You were involved in that incident.
Yes.
Okay. You removed him from the classroom?
Yes.
The incident wasn't something that caused danger or harm to his classmates. It's a cell phone was broken. Is that correct? And that resulted in him being taken to the office. Is that correct?
Yeah, it was like, we just struck up a little bit, but nothing major.
Okay. So, as a staff member, even on that day, you understood it was your responsibility, if you thought that there was a threat to the students, to remove the threat or the students from that danger. Is that correct?
Objection asked and answered.
Yeah, that's fine. Can I have a moment?
Yes, you may have a moment.
No, that's all good.
Thank you. Any brief, direct?
Briefly, yes, Judge.
Yes, sir.
Just so that I understand the timeline of events, you testified on cross that you went and put your eyes on JT. Do you know if that was before or after you spoke with the student and it caused you to go to the assistant principal?
No, before.
It's before, okay. Do you know roughly how long before you spoke with that student?
I do not recall.
Okay. Would it have been more than 2 hours?
It was earlier that day.
Okay. And what were the initials of the student that you spoke to?
I don't remember the first initials are.
Okay, thank you. I don't have any further questions, Judge.
Anything further from the defense for this witness?
Just a moment, Your Honor.
Hello, Mr. Wells. You just mentioned speaking with a student with the first initial of R. Did you ever tell Dr. Parker what R has said to you?
I believe I mentioned what he had mentioned to me, yes.
You believe you did. Do you know for certain whether you
I
did?
am certain.
Okay. Would you be surprised if you did not do that?
I wouldn't be surprised.
Okay. No further questions.
Based on that, I'm going to need a couple of minutes
Okay.
before redirect, I guess.
All right. So we'll take this is a good time for stretch break and after lunch restroom break. So it's 3:25. Let's come back at 3:35. Sir, so you're still under oath, but you can step down and retire to the witness room, and we'll bring you back out, and we'll have the jurors go back to the jury room. Thank you all. 10-minute recess.
Please rise for the jury.
Basically, her reasoning was, if anything ever happens to him, I want to be able to essentially have some sort of like access, control to it. So that's what she said is her reasoning. And she had made some comments like about him unexpectedly passing away. So she'd like brought things up like that before. So anyway, again, just to do it just so we could get the house. I said, that's fine. So it was me, and then it was my parents together, like on the deed. So we closed, and we moved in.
Did your dad give you money for the down payment?
No.
Did he ever pay your mortgage?
No. He actually, in fact, told me before he did it, he said, Emily, if anything happens and you guys can't make the mortgage payment, I cannot make your mortgage payment. And I said, I understand.
Did you expect him to?
No, absolutely not.
You mentioned that your mom would make some comments about what if your dad unexpectedly died. What kind of context was that in?
It was more like there was, my dad was having these like medical health issues where he would feel, they would call them spells, but he would like feel like he needed to lie down, like he didn't feel well. So those were starting to happen more often. And I remember I came to Atlanta from Nashville to go visit my parents one weekend. I think I was by myself that weekend. It was before Olivia was born. And my mom and I had run out to like go to a local nursery, and we had come back, and we were in the car, and she said, like my dad's health came up. She brought it up, and she said, I'm not on any of the bank accounts. And I said, oh yeah. And she said, well, like what will happen if he like passes away unexpectedly? And I was like, what do you mean? She's like, well, he's having all these like spells where he's needing to lay down and all this stuff. I was like, Mama, I just think he's depressed. Like, I just think like, that was the time where it was like their relationship was really bad. And I was like, I just think he's depressed. And when you're in that kind of state, you just need to go lay down. And I was like, but, you know, I did what every child would say to their parent, like, Mama, if that were to ever happen, it would be fine. Everything would be fine. Don't worry. She did bring up something about him having her removed as his beneficiary on her 401k. And I work in HR, so I'm kind of familiar with that. And I just said, I don't think that he can remove you as his beneficiary unless you got a divorce. And she said that he made her sign a piece of paper removing her from the beneficiary. And at the time, I didn't know that much about it, but I was like, if you're legally married, I'm pretty sure your spouse has to be your beneficiary in your 401k. So I just kind of put her at ease in that moment. Like, no, everything will be fine. Like, we'll make sure everything's taken care of. Like, don't worry. If anything like that were to happen, it'll be fine.
Okay. If you could please introduce yourself to the jury.
Special Agent Elena Honey, ELAINAHONEA.
Thank you, ma'am. And was your former last name Coffee?
Yes, it was.
Okay. Can you please tell the jury where you're currently employed?
Georgia Bureau of Investigation.
How long have you been with the GBI?
About 12 and a half years.
What is your job?
I'm currently a crime scene specialist and have been for the last 11 years.
What does that mean?
As crime scene specialist, we specialize in actually processing the crime scene, collecting evidence, and processing items for DNA or latent fingerprints.
Can you tell the jury a little bit about your education and background to get to where you are?
Yes, I have a bachelor's and master's degree in criminal justice. Then when I was employed with the GBI, once I became a crime scene specialist, I've taken several hundred hours in crime scene specialized training to include 400 hours from the
So, Moki is curious about how your day went.
National Forensics Academy, which is commonly referred to as the Body Farm in Knoxville, Tennessee. It's in Oak Ridge, Tennessee.
And do you have to continue training in this area that you work in?
Yes.
How many hours would you say a year do you do continuing education?
Probably at least on a slow year, 40 hours is minimum, but usually it's several weeks of training, which average 40 hours of training a week.
Have you been an instructor for training?
Yes, I have.
Like what kind of training?
I teach an advanced crime scene processing class to numerous local agencies. In addition to that, I have taught basic bloodstain pattern analysis for the National Forensics Academy.
And have you, you've trained in, you mentioned bloodstain pattern analysis. What is that? Can you describe that for the jurors?
That is the basic course. You're identifying what types of bloodstains there are, as far as whether it's a drip stain or just identifying what type of bloodstain it is. In addition to that, you may be able to determine if it's an impact stain, you may be able to determine a point of impact, where somebody was when they were hit that created a blood stain.
And you have another focus in shooting incident reconstruction?
Yes.
And how much training have you had in that?
A lot. I've had a couple hundred hours, I believe, in shooting reconstruction.
Have you ever testified as an expert in criminal trials?
Yes, I have.
About how many times would you say?
I believe around 18, give or take a couple.
Okay. At this time, the state moves to admit Ms. Hone as an expert in crime scene processing to include bloodstain pattern analysis.
As to those issues, I don't have much.
All right. All right, ladies and gentlemen, witness has been tendered as an expert. An expert witness is someone who has experience in training over and above that of a normal layperson, and therefore they are allowed to testify as to their opinion based upon that expertise. All right, go ahead.
And Judge, at this time, I would move to admit her curriculum vitae as well, as states, I guess it would be Hone Exhibit 1A.
All right, any objection? No. All right, submit.
Okay. Am I saying that properly, Ms. Hone?
Honey.
Honey.
Yes.
Okay. You're all saying it wrong. Okay. Did you have the opportunity to get called out to 2155 Purcell Lane on July 7th, 2018?
Yes, I was.
For what purpose?
I was requested to assist with a blue star analysis, which is a chemical that reacts with the presence of blood.
Who did you meet once you arrived on scene?
It was crime scene investigator Daryl Clark.
Okay. And can you tell the jury, you mentioned Blue Star, can you tell the jury a little bit about Blue Star and how that works?
Blue Star, a lot of people have heard of luminol. Blue Star is another chemical very similar to luminol. The purpose of it is to locate blood that is not visible. We have multiple types of chemicals that we can use. If we see blood, we can enhance it. If we don't see blood, we'll use Blue Star or luminol to search for blood.
And does Blue Star does it react to anything else?
Yes, there are false positives, usually a cleaning solution, and I'm sure there's a list of false positives that it could react with.
When it reacts to those other materials, does it react the same way that it does to blood?
It reacts similarly. Usually when you see it, it looks more crystallized. I don't really know how to explain it without actually physically showing you, but it does react with metals as well. So when you see it on a metal surface, it lights up very quickly and then dissipates, as opposed to when it reacts with blood, it stays luminescent for a few seconds longer than when it reacts as a false positive.
Did you have the opportunity to photograph what you did at 2155 Purcell Lane that day?
Yes, I did.
And at this time, the state would move to tender into evidence coffee 1 through 22.
Noted.
If you could please look at your screen for me, and we'll walk through this with the jury. We're looking at coffee 1. Is this one of the photos that you took at 2155 Purcell Lane?
Yes, it is.
Okay, and what are we looking at here?
This is a photograph of the dining room.
And we'll go ahead and move to coffee 2. Is that the same area?
Yes. So the other thing to mention with Blue Star and luminol, it has to be very, very dark in order to see the luminescence of the chemical. So when I'm taking pictures, some of the pictures are going to be brighter than others, so I'll take multiple pictures of the same area if I see luminescence there and maybe the photograph that I took is not fully showing what I'm seeing. So this is just another picture of the same area, the dining room table.
Are you sort of testing your lighting there?
Yes.
And when you have the photo in front of you after you've taken it, can you also adjust the settings of that photo to see the luminance better?
You can on the computer. I'm sure you can on my camera, but I don't.
On the computer?
Yeah.
Is what I meant to say.
Yes.
Okay. Okay, now I'm going to show you coffee 3. Is that same area, different lighting?
Yes.
Okay. Coffee 4, and I'm going to zoom in a little bit on this so you can describe what we're looking at here.
So this is the same area. This is where I actually have the Blue Star present, and you can see that it's luminescing. If you look at the 2 candles.
All right, so if you resume the witnessing and the sheriff, we can bring the jurors back up. Yes, ma'am. Yes, News, you need to come and connect the audio. Oh, please come on up. Okay. Yes, thank you.
I got this one.
You got that one. What about the other one? He said this one. Okay.
Yeah, I turned both of them.
Okay, thank you.
Please rise for the jury. Jurors in the audience.
You all may have a seat. Thank you. You may resume your redirect. I'm sure redirect.
This is redirect.
Okay.
Yes, be quick. Mr. Wells, thank you. I believe you indicated to the defense counsel that you didn't remember what you had told or whether you told Dr. Parker about the incident at the time you asked for permission to search the backpack. Is it true that you don't remember that?
It's been a while, so I don't
Sure.
know.
understandable. Did you give a statement to police in this case?
Yes.
And if I were able to provide you with a transcript of that, might it refresh your memory about what you said to Dr. Parker? Okay. May I approach, Judge?
Okay, yes, and you responded yes, correct?
Yes.
Okay, and he nodded his head, I just wanted to make sure it was recorded.
Thank
Yes,
you.
you may approach.
I'm just handing you this document. I want you to take a look and read there where I put a pink post-it note. And after you're done reading, look up and I'll ask you a question.
No, don't read it. Yeah, sorry. Read it to your. Just read it silently, and then I'll ask you a question about it. Sorry. And does that refresh your memory about what you said to Dr. Parker regarding the incident?
To an extent, yes.
Okay. Would you just tell us then what it was you said to her?
I'm looking at the witness. At this point, he looks like he's looking at the page, and he's going to be looking at the page and then advising. So his memory has been refreshed.
I'll take it back.
Okay.
I'll go
Okay,
get
so
it.
what's your
May I approach?
okay, you just like him to?
I want this done properly. Yes, Your Honor.
Yes, may I approach?
You may approach.
Thank you.
And ultimately, for pardon, the legal principle is you can't read from that statement. You can refresh your memory, but you need to testify from your memory. Okay.
Based on, now let's refresh, if he has an independent recollection.
Well, he said to an extent, so
He did.
we'll flush it out, and we'll give you the opportunity to cross. Go proceed, Mr. Jenkins.
Having refreshed your recollection, do you remember what you said to Dr. Parker prior to asking to search the backpack?
Yes, when I spoke to Dr. Parker, it was already relayed to me that a book bag was searched from JT, and then nothing was found within the book bag.
Do you remember if you confirmed with Dr. Parker that you and she knew what you were talking about? Or who?
I know enough that we confirmed that we thought something may have been in the backpack, yes.
Okay, thank you. I don't have anything further.
And Mr. Rawls, and from what you just recounted, nothing was in the backpack, correct? It had been searched and nothing was there, correct?
That was told to me, yes.
Okay. And at that point, you did not believe there was any credible threat, correct?
Well, that's
Objection
one.
asked and answered on recross.
Oh, I'll withdraw the question, Your Honor.
All right, thank you. All right, anything further for this witness?
No, Your Honor.
All right, and the status for Mr. Rawls, may he be excused or does he need to remain?
I'd ask, I'm sorry.
No, I'll follow you.
I'd ask that he be released.
Oh, no, we're going to ask that he be named.
So we're going to ask that he be constructed. I agree to that. We'll ask that he be constructively sequestered, remain available for recall.
Are you, is that suitable to the defense?
Yes, sure.
Okay, and do you all have his phone number?
No, Commonwealth hasn't.
Absolutely, I do be happy to facilitate that happening.
Okay, so Mr. Ross, what that means is you are still a witness. You still have the ability to be recalled. So do not discuss this case, do not discuss your testimony, but you do not have to stay in the courthouse, you do not have to stay in the witness room. You can leave and go about your daily business. You will either get a phone call, 1, to come back to the courtroom, or 2, that the trial is over and that you are no longer a sequestered witness. All right, any questions, sir? All right, thank you. You may step down. Next witness.
Megan DeLeon.
swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Thank you, ma'am. If you walk around, please take the witness stand, watch your step. The chair and microphone are adjustable. All right, you may proceed.
Good afternoon. Would you please tell us your name?
Megan Delion?
Ms. Dayon, do you have a daughter?
I do.
I want to just caution you, and I know we've discussed this, but during the course of this trial, we're not using any children's names, only using initials or referring to your daughter if you prefer. Back in January of 2023, was your daughter attending school?
Yes.
Where?
Rich Neck Elementary.
Is that here in Newport News?
Yes.
And what are your daughter's initials?
SD.
On January 6th of 2023, did you become aware of an incident that caused you to go to the school early?
Yes.
And when you got to the school, did you immediately see SD, your daughter? Do you eventually see her that day?
Yes, when they bring her out to me.
Okay. When you first see her, describe, without telling me anything she said, just describe her demeanor, how she appeared to you and how she interacted with you.
Initially, she just seemed happy to see me and her dad. It was later on in the evening when she kind of showed different behavior.
By different behaviors, you mean different than prior to the events of January 3rd? Describe what behaviors you observed.
Just that evening, it was a very hectic day, so we just ordered a pizza in and just tried to put some show on to kind of... But the doorbell rang just for the pizza, and she just got very scared and jumped from her seats. The sound of the doorbell and other sounds like that for many months to come just scared her.
What kinds of sounds would scare her?
Slamming of the door, I know, just loud bangs. She described the sound as a ladder falling when the gun went off. So loud sounds have startled her.
Mayor, I'm going to object to her statement. Sounded like a ladder when the gun went off. It sounds like she's testifying to some statements that SC may have stated. If that's what she has done, I'm objecting to the hearsay.
If the request is to strike sounds like a ladder when the gun went off, I agree to that.
Okay, so struck, don't consider that, please. Next question.
So what other behavioral changes, if any, related to SD did you notice in the immediate days and weeks?
Not understanding why this happened. She loved her teacher. The teacher was kind, and she just understand why anyone wanted her
And who was her teacher, if you know?
this morning.
Okay. So Ms. Werner, was Ms. Werner's classroom her homeroom?
Yes.
Okay. As a result of what you observed with SD, did you seek help for her of some kind?
Yes. We went to just regular counseling through our insurance, and then also spiritual counseling through my church.
And how long did that go on for?
6 months.
That's strong objection relevance.
Response.
These are the injuries that the neglect caused, the trauma to the children, and I believe that that is relevant.
So I'll allow it, but do you have additional questions down this line, or do you have additional questions in this line of questioning?
Only to elicit any additional different things that she noticed in her daughter. That's
Okay,
it.
so I'll allow it, you may proceed.
Okay. We're from January 3rd to present. Any additional things you've noticed in your daughter that were not present prior to the January 3rd incident?
She's very, she doesn't want to talk about it. She keeps everything a close hold. She holds in a lot of feelings and emotions. Recently, she went back to counseling because it's the time they said to start doing. To give her some time and re-engage with the counselor, and they said that she has depression, anxiety, and one other thing where she's always on alert.
All right. Thank you. I don't have any more questions for you, but thank you.
Good afternoon, Ms. Deleon. You were never inside of Rich Neck Elementary School on January 6, 2023, correct?
In the building? No.
Okay. And you did not encounter your daughter in the building, correct?
Right out front. No, they brought out to me.
Okay. You filed a civil lawsuit arising from the events of January 6, 2023, correct?
Yes.
In this courthouse, correct?
In this courthouse, well, through Newport News, yes.
Okay.
What do you mean by that?
There's a pending lawsuit in Newport News Circuit Court, correct?
Yes.
Okay. And you named Dr. Parker as a defendant in that case?
Well, I prefer not to talk about my opinions of the case.
Well,
It's more of a
I'm
personal.
going to object, Judge, and ask that we not talk about a child's civil matter on TV, that we have not continue the broadcast while she's speaking about the civil suit that is her child's, really, not hers.
The court's ruling will be the same as earlier, so the objection will be overruled. She's been cautioned that we're only using initials, but the questioning party has a right to cross-examine about interest in the case. And if you just ask who the named parties, not what your opinion is, and I think you said I prefer not to share my opinion on it, so non-responsive as well. Repeat your question, Mr. T.
thank you, Your Honor. In that civil lawsuit, you have named Dr. Parker as a defendant, correct?
Yes, I believe so.
Okay. And you are seeking money damages from the defendants in that case, correct?
I'm more seeking justice for my daughter and what she went through.
And you are seeking money damages from the defendants in that case, correct?
Yes, there is settlement and discussion with that, yes.
Yes, but the loss, I know there are settlement discussions, I'm sure there are. But in terms of what you're asking for in that lawsuit is money, correct?
Yes.
Okay. And you believe that a criminal conviction of Dr. Parker would help in that case, correct?
I don't have any opinion about that or anything to say about that.
Okay. After January 6th, you requested that your daughter be transferred to a different school, correct?
Yes,
And that request was refused by Newport News Public Schools, correct?
it was.
Okay. No further questions.
Thank you. Anything further from the Commonwealth?
No, Your Honor.
And the status of this witness?
We'll ask that she be released, and we're also calling Nicholas De Leon.
Any objection from defense to this witness being released?
No, Your Honor.
Thank you, ma'am, for your testimony. You are released as a witness. You are welcome to remain in the courtroom, or you may leave the building. Thank you. And the next witness's name again, I'm sorry.
Nicholas De Leon.
Okay, Mr. De Leon, please.
Your Honor, I'm going to object to the testimony of the next witness because I believe it's cumulative. I don't think that he will be able to testify to anything other than what is.
I don't know who they are, so okay, tell me why it's cumulative.
How's it walk for him?
Mother and father of the child.
Okay, it's just one witness. I'll allow. I mean, are you bringing out 5 relatives for the same child?
Absolutely not, Your Honor.
Okay,
Absolutely
you
not.
come out
This is
overruled. Mr. De Leon, please.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Yes. Sir, please take the witness stand, watch your step. Chair and microphone are adjustable. You may proceed.
Good afternoon, sir. Would you please tell us your name?
Nicholas DeLeon.
Mr. De Leon, just a reminder that we're not using the names of any children at all, including your own. But do you have a daughter?
I do.
And what are her initials?
SD.
And where did SD attend school?
Richmond Elementary.
Okay. And as of January 3rd, 2023, were you, let me ask the question like this. Who is SD's mom?
Megan DeLeon.
Thank you. Between the time of January 6, 2023, before and after, were there any changes that you noticed in your daughter SD after that hadn't been there before?
Yes.
Could you just describe what you personally noticed or observed, but not anything that she said to you?
I noticed that she was anxious, depressed, very not like herself, as in being quiet, distant, couldn't sleep.
How long did that persist?
Quite some time.
Okay.
Months.
Okay. Did you and her mom seek any sort of treatment for her?
Yes, counseling is for counseling.
Has it helped?
I think it's hard to say at this point. She's still going through counseling. It's been up and down, I think, with her.
All right. And just to confirm, whose class was SD in?
Ms. Wonders.
And was that at Rich Neck Elementary?
It was.
All right. Thank you. I don't have any other questions for you. Please answer any from defense counsel.
Good afternoon, Mr. DeLeon. All right, you mentioned your daughter SD. You don't have any knowledge of whether SD was in the classroom when Ms. Lerner was shot, do you?
I was not there in person, but that is her classroom.
I understand. But you don't have any idea whether she was actually in the classroom, correct?
From what I understand, that she was in the classroom.
And what do you basically understand? Is that from what somebody told you?
Again, I was not there.
Okay.
I can't verify that. But
So you can't verify that. I'm asking you to tell me what you were told. That's hearsay. Okay? Now, you are aware that your wife, or I don't know the status of your relationship, but Megan DeLeon has filed a lawsuit on behalf of your daughter in this courtroom, correct? I mean, this courthouse, correct?
Yes.
Okay. And that you're aware that Dr. Parker is a named defendant in that lawsuit, correct?
That's correct.
Okay. And you're aware that money damages from Dr. Parker are being sought in that lawsuit, correct?
Correct.
Okay. And so you have a financial interest in a criminal conviction of Dr. Parker, correct?
I don't. It's on behalf of my daughter.
Oh, so you believe your daughter has a financial interest in the conviction of Dr. Parker?
Today, that's a separate case.
Just answer my question.
That's a separate suit.
Answer my question. Do you believe that your daughter has a financial interest in the criminal conviction of Dr. Parker?
Today, I don't believe so, no.
Do you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit?
Objection asked and answered. He said no.
No, it has not been asked and answered, Your Honor. I asked a different question.
Well, it's a different question, and I think he already answered it. Are you asking his answer to be struck?
Yes, it's irrelevant and duplicate.
Overruled, and your answer was no, sir, if I heard you correctly?
Correct.
Okay, thank you.
No further.
Questions?
No further questions, Your Honor.
Any redirect?
No, Your Honor.
And status of this witness?
I would ask that he be released.
Any objection?
No objection.
Okay, thank you, sir. You're excused from your duties as a witness. You may stay in the courtroom or leave, as you see fit. Next witness?
Commonwealth will call Tanisha Richardson.
testimony you're about to give is the truth, whole truth, and nothing but the truth?
Yes.
And watch your step, and the chair and microphone are adjusted.
Good afternoon. Would you please tell us your name?
Good afternoon. My name is Tanisa Richardson.
Ms. Richardson, do you have a child?
I do.
And in January of 2023, was your child in school?
Yes.
What are your child's initials?
KS.
All right, and just as a reminder, we're only using initials, not names today. Where was your KS in school?
He was in his classroom. He was in first grade in Ms. Swanger's class at Richmond Elementary.
All right. And did there come a time earlier than normal on January 6, 2023, when you had to go to the school, Rich Neck, to pick up KS?
Yes. I received notice that there was a community post on social media that there was a heavy police presence at the school.
Okay, let me stop you there. Let me, you're okay, just let me ask you questions and I'll walk you through it, okay? So after you saw what you saw online, did you go to the school?
I did.
Were you eventually reunited with KS?
Yes.
Could you describe, without telling us anything that he said, could you describe his demeanor, how he appeared to you when you first saw him?
He was very tired. He was cold. And he was ready to get home. He was just really exhausted from the day.
Yeah. Did you notice any changes in his behavior after January 6th of 2023 as opposed to before?
Yes.
I want you to just describe what you were able to notice as his parent that changed after January 6, 2023.
Kaden experience. Oh, sorry.
It's okay, I
My son
understand.
experienced-
And the news is directed to, they'll believe that, so it's not going to go out to the press. I just wanted to assure you, we will catch it.
Thank you. I'm sorry. Stomach aches, headaches, school avoidance, just a general anxiousness, just extreme fear, as well as hypervigilance.
When you say school avoidance, can you kind of describe to me what that means?
He was literally afraid to return to school.
How long was he afraid to go to school?
I would say until at least the end of the school year of that year.
Did you seek any type of treatment for KS?
I did.
Okay. What did you seek?
He actually had a psychologist initially, and then he also attended CBT therapy with a counselor weekly.
And how long did that go on, and is it still going on?
I would say it lasted about 1.5 to 2 years, and we stopped it since then because his therapist went to a new practice.
Okay. Do you think that it has helped KS?
It has helped.
Good. Thank you. I don't have anything further for you. Thanks.
Good afternoon, Ms. Richardson.
Good afternoon.
You currently have a civil lawsuit pending in this courthouse, correct? Regarding the incidents of January 6, 2023?
Yes.
Okay. And you've also, in that lawsuit, you've named Dr. Parker as a defendant, correct?
Unfortunately, I'm not. I don't feel comfortable discussing the details of that in this arena.
Your Honor, I'm just going to renew my prior objection. I understand the court's rule on the issue.
So the court will overrule the objection. It's appropriate to be discussed. So if you could please answer the question. Repeat your question, Mr. T.
Thank you, Your Honor. In the lawsuit that you currently have filed in Newport News Circuit Court, you have named Dr. Ebony Parker as a defendant, correct?
Correct.
And in that lawsuit, you are suing Dr. Parker and the other defendants for money, correct?
Yes.
Okay. And you and several other parents share the same attorney, correct?
That's correct.
And you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit, don't you?
No.
Okay. Have you made any other demands of Dr. Parker or the other defendants?
No.
Okay. Do you know when that lawsuit is scheduled to go to trial?
No.
Okay. When was that lawsuit filed?
I believe it was February of 2023, maybe.
February 2023?
I don't know. I
Okay.
think it might have been.
Okay. No further questions, Your Honor.
You may proceed.
Just a couple of more questions for you. As a result of the incident on January 6, 2023, and all of the things that your son has done, have you spent money?
Yes.
I'm going to object to go beyond cross-examination.
I think that's right on point with the cross-examination. He asked if she was seeking money in a lawsuit, and I think it's very fair for me to ask if she also spent money as a result of the incident.
I'll allow it. You may proceed.
Did you spend money as a result of what happened to your son?
Yes.
All right, thank you. I don't have anything further.
Anything further for this witness?
No, Your Honor, I ask that she be released.
Any objection to her being released?
No, Your Honor.
Thank you, ma'am. You are excused as a witness. You may stay in the courtroom or leave the building. Next witness.
The next witness will be Ramon Gonzalez. Your Honor, I anticipate having this witness plus one more.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
Please take the witness stand. Watch your step. Answer questions for counsel. Thank you.
Good afternoon, sir. Would you
Good
please
afternoon.
tell us your name?
My name is Ramon Sebastian Gonzalez Hernandez.
Thank you. And I would like to just a quick reminder that during this trial, we're not speaking the names of any children at all and only using initials. Do you have a child?
Yes, sir.
What are your child's initials?
GG.
And did your child attend school, did Gigi attend school in January of 2023?
Yes, he did.
What grade was he in?
First grade
And where did he attend school?
at Rich Neck Elementary.
Do you know who his homeroom main teacher was?
Yes, I do.
Who was it?
Abigail Zorner.
All right. Did there come a time on January 6, 2023, when you had to unexpectedly go to Gigi's school, Richnet?
Yes, I did.
And when you arrived at the school, did you immediately see Gigi?
No, I did not.
Okay, stay with me and let me walk you through it, okay? So eventually, did you see Gigi at the school?
Eventually, yes.
And when you saw him, could you please just describe, without saying anything that he said, describe his demeanor, how he was acting, and how he appeared to you?
He walked out of the school
with a look on his face like he had seen a ghost, pretty much. I was crying myself. He wasn't crying, but he was in shock, like complete, utter shock.
Okay. And from that moment forward, did you notice any changes in behavior from Gigi as opposed to before January 6th?
Yes, at home he was a little bit snappier with his brother. Whenever they would argue, he would be a little bit more aggressive. Other things like he had to sleep with him every night because he just felt more comfortable. Bedwetting almost every night. Things like that.
And were all of those things new after January 6th?
That was new after that. Okay. He loved to sleep by himself before that.
And did your family seek some help and treatment for Gigi?
Yes, we did. Right after the incident, we went, I want to say 2 or 3 times. Mm-hmm. And he was very adamant that he didn't want to go because we wanted to keep his life as normal as possible after the incident. So wasn't trying to force it down his throat.
Okay. And has he, at any time between then and now, has he sought any treatment beyond that?
Not since then, no.
Okay. And how long did any concerning behaviors that you've described last?
It still lasts to this day. Getting better gradually, I think. But still, he has a lot of mood swings, and the whole big wedding thing that happens. It's pretty rough.
Did your family incur any expenses as a result of this?
As far as with the
for Gigi, as a result of this, did you have some expenses?
No, with the therapy that was provided, so we didn't have any expenses as far as that.
Okay, thank you. I don't have anything else for you.
Okay, thank you.
Good afternoon, Mr. Gonzalez.
Good afternoon.
You weren't at Rich Neck Elementary School on January 6, 2023, correct?
I picked up my GG that day.
But you were not inside of the building, correct?
No.
You learned about the shooting after the fact, of course. Did the school contact you at the time of the shooting?
No. I had a friend of mine, a coworker, contact me and told me about the shooting.
But did the school ever contact you?
Afterwards, yeah.
How long after?
I would say an hour and a half.
Okay. Your child was not in the classroom where the shooting occurred, correct?
Yes, he was.
Okay. And you're saying he was a student in that classroom?
He was a student in Ms. Werner's classroom.
Okay. And you filed a civil lawsuit in this case, stemming from the events of January 6, 2023?
I don't feel comfortable talking about that.
And Your Honor, I'd like to note my continuing objection.
Okay, so noted. Sir, you do need to answer the question, please.
Yes.
Okay. And you have named Dr. Parker as a defendant, correct?
Yes.
All right. You're seeking money damages from Dr. Parker in that case, correct?
Yes.
Okay. And a criminal conviction of Dr. Parker would be helpful to that lawsuit, wouldn't it?
I'm not sure about that.
Okay. No further questions, Your Honor.
No, Your Honor, I ask that he be released, please.
Any objection from defense?
No objection, Your Honor.
Okay, thank you, sir, for your testimony. You may step down, and by release, you can leave the courtroom or stay in the courtroom, but you're no longer needed as a witness. Thank you.
And the Commonwealth will call Sarah Gonzalez.
Your Honor, again, we're going to object. This is a duplicative witness that adds nothing to the case. This is the last other parent of the child, the second parent of the child.
So noted, overruled. You can bring out the witness. Thank you. And this is the last witness?
This is the last witness, Your Honor.
I'm not going to, I'm just trying to line up.
I understand. I I understand. I will take a moment to double check that this is
Understood.
that we're
Understood.
into, but yes.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Thank you, ma'am. Please take the witness stand and watch your step. Chair and microphone are adjustable. You may proceed.
Good afternoon. Would you please tell us your name?
Hi, Sarah Gonzalez.
Ms. Gonzalez, do you have a child?
Yes,
Remember that we're only using initials or referring to your child as my child. What are the initials of your child?
G.
And who is Gigi's father?
Ramon Gonzalez.
Okay. I want to take you to January 6th of 2023. On that afternoon, where were you when you first see Gigi?
After the incident, when I saw him,
When you first see him on January 6th, 2023.
at our home,
Okay. When you first see him at your home, is it still on January 6th?
yes,
And do you know roughly what time it would be?
it was in the evening.
Okay. Could you just describe for me, without telling me anything he said, but could you describe his demeanor, how he appeared, and how he was acting toward you?
When my husband came home with him in the car and he came out, he was like he had seen a ghost, kind of. He was white, and his eyes were very big, and he was just kind of, I've never seen that look before, but he was kind of like he was in shock.
Okay. Were ongoing after that day, were there any issues with Gigi that you noticed that were different than prior to the January 6th?
Yes.
Describe those to us.
He couldn't sleep by himself anymore. He had to sleep with someone else, and it just is, to this day, he still sleeps with his older brother, and he just refuses to sleep by himself. And he frequent bedwetting started occurring after that, and frequent bouts of losing his temper, and just becoming angry, things like that.
Yeah. And for how long did those things last?
For a long time. It's improved, I would say, but it still occurs. It was very frequent after that for quite some time.
Were there any other major life adjustments that your family had to make as a result of what Gigi went through?
Just trying to internalize it and, move forward, and, it's the impact on my husband and myself. It was pretty significant and caused a lot of anxiety, and,
Just involves the impact on the ball.
I agree, Judge. We won't go down that road.
Okay, so we won't consider that just to the child. Next question.
I don't have any more questions. Thank you so much. Please answer any questions from defense counsel.
Good afternoon, Ms. Gonzalez. You have filed a civil lawsuit in this courthouse as well. regarding the events of January 6, 2023, correct?
I don't feel comfortable speaking on that, as it's relevant to my son.
Okay, objection noted, and you do need to answer, please. Repeat the questions.
You have filed a civil lawsuit related to the events of January 6, 2023 in this circuit court, correct? And you have named Dr. Parker as a defendant in that matter, correct? And you're seeking money damages from Dr. Parker and the other defendants, correct?
Am I still liable to speak on this?
Yes, ma'am, you need to answer the question, please.
Yes.
Okay. In fact, you and several other parents are represented by the same attorney, right?
Objection, Judge, that is not who they are represented by in the civil suit. It's not in any way relevant.
Response.
I think it's relevant. We have a series of witnesses, all filing civil lawsuits, and represented by the same attorney. I think it's totally relevant to these proceedings.
And I object to counsel saying they're all represented by the same attorney. He's not testifying.
Correct, that's not evidence.
Well,
I'm going to sustain the objection. Who their attorneys are is not relevant. But, you know, that there's a lawsuit is relevant for cross-examination. Next question.
And a criminal conviction of Dr. Parker would help in that lawsuit, right?
Imagine, yes.
What was your answer? I'm sorry?
Yes.
Okay. So you have a financial interest in these proceedings, right? I'm sorry?
I imagine that's part of it, yes.
Okay. No further questions.
That's all for this witness, Judge, and I would ask that she be released.
Any objection? Okay, ma'am. So you are excused from being a witness. Thank you for your testimony. That means you can stay in the courtroom or you may leave. And watch your step as you step in.
Judge, may I have just less than 1 minute?
Yes, sir.
To confirm.
You can sit down. Thank you, ma'am. And the sheriff will direct you.
Your Honor, the Commonwealth Press.
Your Honor, we will have motions to strike, but I do want to take time with my co-counsel and the defendant to make sure that we have every base fully covered. So I'm going to ask the court to consider going on recess for the remainder of the day, and then we'll come back first thing tomorrow and make our motions and present any evidence on behalf of the defense.
Commonwealth, in terms of proceeding in that chronological fashion, your position.
I'll submit to the court.
Okay. All right, so to the jury, we take up the motion to strike outside of the presence of the jury. It's 4:25 today, and they're asking to do so in the morning. So I will kindly ask you all to report back and would you like the jurors to report? What time is the council prepared to do motions to strike in the morning? 8:30 or 9? And I'll give that an hour and ask the jurors to report an hour after that.
Any time is fine for you.
Understood.
Your Honor, if we can be prepared for 9 o'clock tomorrow morning.
Say that start at 9?
Yes, 4 motions to strike. Yes.
4 motions, and ask the jurors to report at 10.
Yes, ma'am.
Okay. All right, so thank you again for day 3. You have the same cautionary instruction. Please do not discuss the case, research the case, allow others to discuss it and or share their discussions, their thoughts, and opinions with you. I know that's hard. I know this is a high-profile case, but that is important to the integrity of the process. And please report at 10 a.m. Are there any issues, anything I can assist you all with? Okay, and last, please, I will not be able, the court to provide lunch tomorrow. My assistant's off. And she's the one who, while we're here, actually goes to pick it up. So bring your lunch or be prepared to go out to get food tomorrow. All right? Thank you very much.
Please rise for the jury. Make sure you use your notebook.
Anything else from the Commonwealth of Defense to take up before we can make our evening recess?
No, Your Honor.
No, Your Honor.
All right, we'll be in recess. Thank you. See you all at 9 a.m.
Thank you. Thank you.
All right, and if they'll come, oh, I saw him use that.
Okay, everyone. The trial is over for the day, and I am right about to launch another stream right now, which will be the Melody Ferris trial. We'll continue to watch the replay of it. So this stream is going to be ending, but right now another stream will be launching. That will be the Melody Ferris trial replay. To move and this stream will be over. All right, so thank you all for watching this, and hopefully see you all on the stream that's going on right now.